모든 국민은 인간으로서의 존엄과 가치를 가지며 행복을 추구할 권리를 가진다. 국가는 개인이 가지는 불가침의 기본적 인권을 확인하고 이를 보장할 의무를 진다. 대한민국 사법부는 국민의 기본적 인권과 정당한 권리 행사를 보장하고 이를 통해 자유, 평등, 정의를 실현할 사명을 국민으로부터 엄숙히 부여받았습니다. 격동의 역사 속에서도 대한민국 사법부는 국민의 자유와 권리를 최대한 보장하고 소수자와 약자의 권리를 보호하는 최후의 보루로서 그 소임을 다하여 왔습니다. 대한민국 미래 사법의 청사진을 제시하기 위하여 2014년 사법정책연구원이 출범하였습니다. 대한민국 사법부의 명실상부한 싱크탱크 사법정책연구원. 사법정책연구원은 현실과 예상, 실무와 이론을 아우르는 체계적인 연구를 통하여 미래의 사법부가 추구해야 할 바람직한 모습을 제시하고 있습니다. 국내를 넘어 세계를 향해 도약하는 사법정책연구원.
사법정책연구원은 대한민국 사법부의 싱크탱크입니다. 국제적 기준에 맞추어 우리 사법의 미래를 구상하고 사법제도의 개선을 위하여 노력하고 있습니다.
대한민국 사법부는 투명한 절차와 공정한 결과를 통해 국민이 수긍하고 감동하는 좋은 재판을 해나갈 것입니다. 이를 위해 사법정책연구원은 새 사회의 흐름에 부응하는 새로운 사법정책과 제도를 연구함으로써 국제적 수준에 걸맞은 사법정책을 제시하겠습니다. 미래를 여는 사법정책연구원.
Good afternoon, distinguished guests. Welcome to the second day of 2020 JPRI International Conference. I'm Dr. Hyojung Kim, a professional researcher of JPRI. I hope everyone has slept tight last night and ready to participate in inspiring sessions today. I would like to kindly remind you that we are broadcasting the entire conference live on YouTube, Judicial Policy Research Institute channel, for the people who could not attend at this venue in person. As with yesterday, we'll provide simultaneous interpretation service for the convenience of multinational participants. Please take your receiver and select channel 1 for Korean and channel 2 for English. Please wear a mask for your safety. You can have an extra mask at the registration desk if you need one. Anyone in the audience who have any questions, please access to the online Q&A session by scanning a QR code which is displayed on the banners at the lobby. Now, let us begin session 4. Our topic for session 4 is International Commercial Court and Electronic Litigation, focused on the e-service. It gives me a great deal of pleasure at this time to introduce the moderator who will lead this session. The moderator of this session is Mr. Young-suk Lee, President of Korean International Trade Law Association. President Lee graduated from Seoul National University College of Law in 1985 and began his legal practice since 1987. He founded and led the International Dispute Resolution Team at law firm Judicial. He founded Rosetta Legal in 2017, and he has handled various international disputes, including international arbitrations. He is a renowned authority who leads the international arbitration practice in Korea. Ladies and gentlemen, please join me in welcoming him with a warm round of applause. President Lee, the floor is now yours.
Thank you, Dr. Kim, for very kind introduction. Good afternoon, everybody, and also good morning to one of the speakers, Mr. Brody Warren, who will be the first speaker of today's session. As Dr. Kim introduced, the topic of our session, the first session in day 2 of this conference is International Commercial Court and Electronic Litigation, with a focus on e-service or electronic service. I understand that Korean government is considering establishment of international commercial courts in line with the recent trend globally. And JPRI, the Judicial Policy Research Institute, recently commissioned a report on this international commercial court, and the result of the research commission is this report. Probably you all have received this report. And before we further consider whether and when and how we will adopt international commercial court system in Korea as well, it will be very useful to hear about the practices in other countries where international commercial court has already been adopted. We have in this session 2 speakers and 2 panelists. 2 speakers are from Mr. Brody Warren from HCCH and Mr. Jung-hwan Kim from JPRI. He is the person in charge of this extensive report on international commercial court. And we have also 2 eminent panelists, Mr. Justice Quentin Law from the Supreme Court of Singapore and Ms. Joo-hyung Lee, Director of International Affairs from the National Court of Administration of the Korean Supreme Court. I will introduce each of them in more detail before they speak respectively. The first speaker is Mr. Brody Warren from HCCH, as I just introduced. And Mr. Brody Warren began in the International Legal Cooperation and Civil Procedure Team of the HCCH Permanent Bureau in 2014. As part of this team, his work spanned a number of HCCH conventions such as apostille, service, evidence, access to justice, and civil procedure. Following his appointment to the position of attaché in 2020, Mr. Warren has continued to work on the apostille convention. And it is obvious from, I will stop here. He is the person who is very has a deep expertise in the topic on overseas service and also electronic service. and we will hear from him about e-service under the HCCH Service Convention, and he will certainly address the issues on electronic service as well. I will hand over the floor to Mr. Brody Warren if he's ready. Are you ready?
Yes, good afternoon, everyone, and thank you very much, President Lee, for this very kind introduction. Before I begin, I should also thank all of the organizers, in particular the Judicial Policy Research Institute and the Secretariat for having me. It's a shame that we were unable to make it there in Seoul, but it's a pleasure to participate, at least remotely from The Hague this morning here for me, but this afternoon for you. So I'm just going to start my presentation. Hopefully that one shows up on the screen there. Yes. So as mentioned, I'm going to be focusing on the use of electronic means or e-service under the HCCH Service Convention. Of course, there are a number of other conventions that are relevant to international commercial, the possible international commercial court, and also to international commercial litigation generally. I know you've already heard about a few of them yesterday, and I'll do my best to, in the next few minutes, to outline the basics of the Service Convention, and also a little bit about how exactly electronic means typically can be used under the HCCH Service Convention. So to begin with, I'll focus on the Service Convention itself. As some of you may know there, I've listed the long title, and it actually will celebrate its 55th anniversary this coming Sunday of the adoption of the convention. Obviously, that means that back in the 60s, they were not necessarily thinking about the kind of electronic means and technology that we're using today. But as I'll hopefully show to you through this presentation, we'll be speaking about just how the Service Convention has been able to maintain a presence around the world today. To give you a bit of an idea, at this point in time, we have 78 contracting parties to the Service Convention. Most recently, I believe the Marshall Islands joined just a couple of months ago. As you can see, there's quite a spread of different legal systems. There's a little bit of work that we have to do in the middle of the map there in terms of getting more contracting parties. But in general, there's quite a diverse range of judicial systems, particularly across the common law and civil law divide, that the Service Convention tries to bring together. The main objectives of the Service Convention, the negotiators of the convention were looking to simplify and to expedite or to speed up the transmission of requests for service abroad. The added element of the Service Convention is that they're facilitating proof of actual notice to the addressee and proof that the service has actually been effected in terms of the certificate that's required to be used under the convention. And the other element that's quite important when dealing with transnational litigation is that the convention only applies if and when the internal law of the state of origin requires transmission abroad for service. So it's also about providing different channels, what we call channels under the convention, without necessarily changing the domestic law of the states involved. As some of you may be aware, there's sort of three general main groups of channels under the convention. The first one is what we call simply the main channel, and I'll explain that in just a moment. In addition to the main channel, which operates between central authorities, there's also what we call alternative channels. There are things like diplomatic and consular channels, postal channels, and then also direct communication between judicial officers. As well as then the derogatory channels, which is sort of leaving priority to other bilateral and multilateral agreements in the area of cross-border service. But to come back to the main channel, in this instance, you've got a request to serve in what we call the requesting state. Under the main channel, Article 5 of the Convention, if and when there is an occasion to transmit abroad for service, a forwarding authority of the requesting state will use the model form that's required to be used under the convention to transmit directly to the central authority of the requested state. As you can see there on the diagram, it's sort of the central authority of the requested state then either affects the service directly or arranges for it to be affected by, for example, another competent authority. Then the certificate of service is filled in. That's also part of the model form that's required to be used under the convention. And that is transmitted back to the forwarding authority in the requesting state to essentially demonstrate that service, well, assuming that it was, but it was affected correctly and with the conditions under domestic law. The interesting thing about this is that not only was this, I mean, it seems somewhat quite simple at this point in time, so I guess the negotiators of the convention achieved that simplification that they were after. It also simplifies the procedures as compared with diplomatic and consular channels and the traditional way of transmitting requests abroad. But also that under this mechanism, it's simply a transmission under the convention, but then the service itself is actually affected under the internal domestic law of the requested state. That's why it's important that the central authority is the mechanism that receives it there. As I mentioned before, there are a number of other channels that we talk about under the convention. This is essentially to provide multiple options for the states involved. The main channel is always available, sort of the central authority channel, but these alternative channels are options for the states and contracting parties to the convention. A contracting state may object to any one of the alternative channels. So the first one that I mentioned before was essentially the traditional. It preserves the possibility of using diplomatic and consular channels, and the diplomatic channels are kind of preserved in exceptional circumstances only. But that's up to the state to decide. The postal channel, we'll come back to that a little bit later on, but essentially the idea that the states are free to transmit documents for service directly to the addressee abroad, provided that their own law allows for service by mail and that the other state, the requested state, hasn't objected to the use of that channel on its territory. And finally, the third alternative channel is the direct communication channel. We've sort of got both Article 10B and C there, but the idea that it recognizes the flexibility of judicial officers to communicate or transmit, documents for service and effect service between so that's sort of judicial officers, sometimes bailiffs, huissier, that sort of thing, depending on the system. But again, the Service Convention was not trying to restrict in any way. It was trying to preserve existing means, but also provide a kind of some certainty around what the main channel could be and always have that one available, in addition to having these other channels. And as I mentioned before, the derogatory channels are essentially ones that allow or give priority to other bilateral agreements, multilateral agreements, and allows contracting states to agree on other methods of transmission there and permitting things when it's essentially a less burdensome or more favorable method of service for incoming documents as well. But in the context of, I guess, leading to electronic means in particular, so when the convention applies, we have essentially four main conditions. The first is what we're talking about in terms of the scope of the convention being civil and commercial matters. So that's why it's particularly relevant to international commercial litigation. But the Service Convention is also used quite often in family law matters as well. That scope aspect is usually relatively easy to determine if we're talking about electronic means. The second condition there in terms of the documents, so the documents to be served need to be judicial or extrajudicial in nature. That's determined by the requesting state as well. But it's these last two conditions that are actually a little bit trickier in terms of electronic means. the third one there in terms of transmission for service needs to be abroad, in the sense of it has to be got the occasion to transmit a request for service abroad from one contracting party to the convention to another. And the fourth element there is that the address of the person upon whom the documents are to be served must be known. And I should mention that this is deemed, and the Special Commission has said on a number of occasions that this is more than simply knowing the town where the person is located or something like that. It needs to be an actual address. Some central authorities have the means to sort of correct an address if it's not quite correct, that sort of thing. However, there has to be kind of some knowledge of where the addressee is located. Obviously to determine whether it's abroad, but also to know their address under the terms of the convention as well. So I suppose that gives you a little bit of background in terms of how the general operation of the convention works. But specifically in the context of electronic means, I suppose this is where we kind of talk about what does this mean, and what do these channels that were developed back in the 60s, what does that mean for us today with the new technology? Which has essentially given rise to a sort of quite an interesting question, or a distinction that's quite important under the convention. The convention title actually refers to the transmission of documents abroad for service. And that's where the difference is quite important in terms of the transmission of the request, or the sending of the request abroad, and the actual execution of the request in the requested state, and that is the sort of effecting of service abroad. So when we're talking about electronic means, of course, the convention is drafted in a manner that doesn't mention any particular technology, and if the states involved have the means to transmit a request abroad electronically, that's certainly permitted or open under the convention. And that's essentially, as long as it fulfills the requirements of each of the channels and the requirements of the convention, that transmission can take place electronically. The execution, as required by electronic means, with a couple of exceptions, in general, it's done under the law of the requested state or the state of execution under the convention. And so that's why it's important that the domestic law of the state, and not the convention, but the domestic law actually provides for the use of electronic means in effecting that service upon the addressee. So that distinction, as I said, is quite important when we're dealing with electronic means. In terms of what this means in practice under the convention, the transmitting for e-service, we might see, for example, under the main channel in Article 5, that between central authorities, they simply send requests electronically. Under Article 9 with diplomatic channels, if a state's diplomatic services allow electronic transmission, if there's some kind of electronic system for requests, that is also possible under the convention. And the same thing in terms of judicial offices. We're aware that in some jurisdictions, they have judicial offices have a sort of electronic transmission network where they can transmit requests between themselves. And that's why the electronic means is quite important in terms of the transmission aspect. But as for directly affecting service under the convention in East electronically, there are essentially only two channels that we're talking about where you could actually have not just transmission, but also actual service electronically when it's outside of the original channels that rely heavily on domestic law. The first there is diplomatic or consular agents, where we're talking about, again, if the diplomatic services or consular services of the state concerned are equipped to serve electronically on their own citizens, for example, abroad, and the state in which the diplomatic mission, for example, is located has not objected to the use of that channel, then that could be one option where service could actually be effected electronically. And the other interesting one is postal channels, in the sense that if it's as long as it's permitted under the law of the state of origin, and as long as the state of execution or the requested state has not objected to the use of the postal channels, then that could be an option where it could be executed or transmitted electronically. And that's because while we may conceive postal channels as traditional mail, there is an argument to be made, and we've seen it in case law and legislation, that this can also include electronic means, and that, for example, secure email or an electronic mail platform, things like that could be used under Article 10A as well. But as I'm just going to quickly come back to this again, because the conditions are also still very important in terms of the way that they apply. If I take the postal channels example, we know if you've got a request for service and it can go under Article 10A, and you know quite quickly whether it's a civil commercial matter, whether it's judicial or extrajudicial in nature, the documents, but then to determine whether it's abroad and to determine the address of the addressee, those last two conditions become a little bit more, or make things a little bit more complicated. And the address, for example, it has been again established by the Special Commission of Contracting Parties to the Convention when they've met that a simple email address is not enough to determine or to fulfill the requirement of the address under the Convention. So I guess while the Convention is quite flexible in terms of it being open and doesn't privilege one technology over another, or it doesn't necessarily say that it has to be in paper form, and we've actually been able to take it quite far in terms of this open and kind of modern reading of the Convention, there are still these fundamental requirements which do need to be fulfilled in order to be within the scope of the Convention. In terms of where that fits, I guess, in the overall e-litigation picture, and just wanted to come back to a couple of these. Service is essentially just one piece of the puzzle. As you would have heard yesterday, in terms of another number of HCCH conventions and instruments, the Choice of Court Convention, the Judgments Convention, the Choice of Law Principles, but also, for example, the 1970 Evidence Convention, that's more about the taking of evidence abroad, but could be in a very important convention. But of course, the focus of this session is e-service, but the Evidence Convention is worth mentioning purely because it also operates with a central authority mechanism and has a number of other channels for taking evidence abroad as well. But ultimately, the point of all of these conventions is to provide legal certainty and predictability, to facilitate the cooperation mechanisms between the contracting parties, and whether that be in paper or electronic form, and ultimately to hopefully provide better rule of law and access to justice for those involved and those operating in cross-border situations, whether that be commercial or otherwise. And I suppose just to sort of fit that in the overall concept of the technology in the HCCH conventions, all of these conventions have been drafted in a way that what we call is technology neutral. As I said, it doesn't necessarily privilege one convention or one means of technology or another, but they're drafted to allow for the use of modern technologies, and that has been something that's been confirmed on many occasions by the contracting parties and state practice. There's also a regular review of these practices. So when issues, particularly in relation to technology, come up, they can be discussed among the authorities themselves. There's guidance provided, for example, in the service handbook that we've published from the Permanent Bureau, but together with a number of states involved, and was also approved by our council of members. The technology then allows for a kind of more efficient and more effective and ultimately more accessible operation of the convention. The difficulty, though, is that it can only really be efficient and effective and more accessible if it's accompanied by this sort of proactive and cultural shift too, because I think we are still relying on this fundamental notion of paper being the only form of original, of request, things like that. But as things with digital signatures, electronic means of transmission, as technology progresses in that sense, we should be able to start embracing these new technological developments. And ultimately, if domestic law provisions allow for them, which is also an element that domestic law needs to make sure that it keeps pace with technology a little bit, we can ultimately eliminate the need for paper or hard copies in some cases, if not eventually, possibly all. But ultimately, the increased use of technology under the HCCH conventions, but also under other international instruments, will facilitate the sort of better access to justice for all those involved in cross-border situations. So at this point, I'll leave it here, and I hope that I've provided a sort of good introduction then of the HCCH Service Convention in particular, and how that relates to the use of technology and e-service in particular. But of course, I'd be very happy to participate in the discussions, and I look forward to hearing from my fellow speaker and then also the panelists after. So thank you very much.
Thank you, Mr. Warren, for your excellent presentation. It is obvious that Mr. Warren had a lot to cover in his presentation, so he spoke very fast. Mr. Warren explained about the service convention in general and how electronic service can be done under the convention. And it seems that although service convention was prepared almost 40 years ago, it still can be used to encompass electronic service with some adjustment at the national legislation level to cover new development. And we will now move on to the next speaker, Dr. Jung-Hwan Kim from JPRI. Dr. Kim is a research fellow at Judicial Policy Research Institute, JPRI. He holds LLB, LLM, and PhD degrees in law from Korea University in Seoul, Korea. His research interests include electronic evidence and e-discovery, blockchain and law, and international commercial court, legal interpretation, and complex litigation. So he is obviously a very good fit to cover the issue today. His specific topic is international commercial court and electronic litigation, just the topic of this session. I'll hand over the floor to Dr. Kim, please.
Good afternoon. My name is Jung-Hwan Kim, and I'm a research fellow at JPRI. Before we get started, I really appreciate this opportunity to present my research on international commercial court and electronic litigation. In my presentation, I will first discuss the status of international commercial courts establishment and its features. Second, I will examine reasons why international commercial courts are actively adopting electronic litigation system. Third, I will discuss the effect of electronic litigation platform since their adoption and the feedback on the platform by users. Last but not least, I will talk about blockchain technology, especially about its application in international commercial court regarding electronic filing and service. First, I would like to briefly talk about international commercial courts. International commercial courts emerged as a new means to resolve international commercial disputes. It was an attempt to solve problems in international commercial arbitration. So, international commercial courts have unique features imported from arbitration. On the screen, you can see common features of international commercial courts. Among these features, I want to focus on the active adoption of technology by international commercial courts. Now, on the screen, you can see the status of establishment of international commercial courts. Let's investigate in detail why international commercial courts are actively adopting technological tools, notably electronic litigation. Since international commercial courts handle international commercial disputes, they aim to relieve financial burden and inconveniences for parties and also to resolve the dispute efficiently. And technology adoption is one of the means to accomplish their goal. Technology improves accessibility to the courts by overcoming the physical distance between parties and the courts. They also eliminate unnecessary expense from procedures such as submission of paper documents. These are reasons why international commercial courts are actively seeking to incorporate technology. In addition, the recent eruption of COVID-19 pandemic has been a stimulus to incorporating technology more aggressively by international commercial courts. Many international commercial courts develop and operate a variety of systems. Let's look at cases where electronic litigation is frequently used. Obvious case is online hearing for litigants or parties who are far from each other. Online case management, as well as electronic filing of trial documents and electronic service via platform are other cases where electronic litigation system is frequently used. Participants who have been involved in dispute resolution via international commercial courts have provided positive feedback on technology adoption by international commercial courts. According to the surveys conducted by Singapore International Dispute Resolution Academy from 2016 to 2018 for lawyers and corporates who participated in international commercial disputes, 51% answered e-discovery and due diligence of international commercial courts were either extremely useful or useful, and 34% answered virtual hearing platform was either extremely useful or useful. However, we should note that majority of international commercial courts have chosen a centralized system in which courts are in charge of managing all features of the electronic litigation system. Due to the nature of judiciary duties in international commercial courts, high degree of security is necessary for verification and prevention of forgery in electronically served documents. In a centralized system, this task must be delegated to a trusted third party, which results in great expense for security and system implementation. In addition, data loss from cyber attack on a centralized system can result in significant damage to the entire network. Therefore, additional costs will arise to prevent such attacks. Other possible problems include failure of a real-time update of trial status for the participants, or the status of trial is not shared among the participants in real time. This slide shows characteristics of current centralized system. Then we can ask, is there a solution to these problems? blockchain technology has been gaining attention to address the shortcomings in the centralized system, and courts are no exception. Among international commercial courts, Dubai International Financial Center Courts is planning to build the world's first court of blockchain since 2018 as part of the Smart Dubai project and Dubai Blockchain Strategy 2020. Courts in China, namely Hangzhou Internet Court, accept blockchain evidence and uses blockchain for forgery prevention. Last but not least, Thailand's Office of the Court of Justice announced that they will adopt blockchain technology to manage judicial record. Next, I would like to go over fundamental concepts in the blockchain technology. Blockchain is a technology that periodically creates a block of data and link with the existing block. Data is a ledger, which is a record of transactions among parties. Since the ledger is copied and distributed to the parties in the blockchain network and validated collectively, it is also referred as distributed ledger technology. This figure describes the fundamental structure of blockchain. Decentralization, transparency, immutability, and availability are properties of blockchain technology. Decentralization is the most important property in blockchain. Ledger is verified, validated, confirmed, and consented directly by the participants rather than by a third party, such as a government or bank. Next property is transparency. In blockchain, as soon as a new block is created, it is distributed to and shared by all participants. Hence, any participant is able to see and monitor the transactions on the block. It is important to note that anonymity is maintained. Third feature is immutability. Once blocks are linked in sequence, it is impossible to modify or delete linked blocks because hash value from the previous block is used when creating a new block. Blocks in all participants' computers have to be updated in order to modify or delete contents in any block in the sequence. Final feature is availability. Data in block is copied and stored across the nodes, which are participants' computer. This implies that even if one node in the group experiences a system failure, the remaining nodes will continue to function and the system will remain in operation. This slide shows the difference between centralized system and the decentralized system. The early model of blockchain was public blockchain, meaning that anyone could participate. Later on, new type of blockchain that required permission to join and participate. This is private blockchain. The difference between two systems is that public blockchains allow access to anyone. Since there is no central controller that supervises the entire system, it is controlled and regulated by a program. Participation is anonymous, and a large number of potential users can result in relatively slow speed. On the contrary, private blockchains require permission to participate, and participants are identified in the approval process. Hence, anonymity is not warranted. There is a central controller who oversees the entire system. Private blockchains provide faster speed than public blockchain because only approved users are able to participate. Private blockchains would be appropriate for governments or corporates in which speed and confidentiality are priority. Smart contract refers to various computer execution commands embedded in blockchain. In simple terms, it is a self-executing programming code that runs in blockchain. In blockchain-based smart contract, the corresponding contract procedure is composed beforehand and runs automatically by a code distributed across blockchain. Validation process is substituted with proof of work, hence unnecessary in blockchain. Now, I will talk about the electronic document management model with blockchain. Submission and service of documents require convenient traceability as well as high level of security to prevent document forgery and information leakage. Validation and preservation of data integrity are also important aspects. Blockchain technology can provide following advantages. First, with blockchain, data is immutable, and as information is distributed and shared among participants, validation process is deemed unnecessary. Next, the advantage of system in which encrypted data blocks are distributed and shared among the participants obeys additional security expense. As a result, high degree of security and efficiency can be achieved at reduced cost. Let's look at systems in more detail. If international commercial courts were to adopt blockchain technology for document filing and service, courts needed to choose between public or private blockchain. Public blockchain requires complicated algorithms to handle the participation of a large number of people, which would result in slow speed. On the other hand, private blockchain comprised of international commercial courts, parties, and legal representatives will provide faster speed and higher level of security, hence more suitable for international commercial courts. Blockchain ledger must have timestamp function, which records the time when the documents are filed, served, and received. The information must be readily accessible by parties, and parties must be able to make queries on the tracking information of the documents that electronically served by a blockchain. It should also allow identification of sender and recipient and trial document tracking. Forgery prevention is the most important issue with court documents filed and served via blockchain. Hash value from stored records and the location of data storage can be considered as a possible solution. Immutable property of blockchain data is another potential solution to validate and verify court documents. With smart contract, it is possible to develop algorithms to handle a number of different scenarios and utilize them in unexceptional or frequently occurring events. This figure shows the electronic document management model with blockchain that I discussed. I would like to finish with a brief summary. Due to the nature of international commercial disputes, international commercial courts are actively seeking to adopt technological tools such as electronic litigation, and recent eruption of COVID-19 pandemic has accelerated this phenomenon. However, international commercial courts have chosen a centralized system which is vulnerable to cyber attacks and requires additional systems to ensure system security and document verification. Additional security system needs to be implemented to address these problems. Hence, a centralized system can be more costly. Considering these disadvantages, blockchain technology is an alternate solution that can reduce financial burden and lead to great efficient system implementation. However, as SIFOCC, the Standing International Forum of Commercial Courts, have pointed out, while emphasis of technological efficiency and economical solution is an ideal goal, it can lead to digital divide or unfair distribution of information to parties such as self-represented litigants who may lack legal resources. I would like to conclude this presentation with the following point. Fairness and appropriateness are equally as important as efficiency and economical solution. Thanks for your time.
Thank you, Dr. Kim, for your excellent presentation. We have heard from Dr. Kim about the international commercial courts in general and also a new IT technology, including blockchain, that can be used for electronic litigation. I think since international commercial courts will be new, it can be considered, adoption of new technology can be considered at the time of initiation of the service by international commercial courts, but at the same time, it can be used for traditional courts as well. We now have two panelists to make a presentation, but the clock tells me that time is already out, but we will have to listen to the two speakers. So my only request to the two panelists is that they try to make the presentation somewhat shorter than they already prepared. Our next panelist to hear from is Justice Quentin Law from the Supreme Court of Singapore. Justice Quentin Law was appointed a judicial commissioner of the Supreme Court of Singapore on 1st of September 2009 and a Supreme Court judge on 1st of June 2010. He is the judge in charge of the Singapore International Court and concurrently was also appointed a non-permanent judge of the Supreme Court in Fiji from August 2018. He was made an honorary bencher of Middle Temple in 2017. He is a member of the Judicial Committee of the Academy of Experts from 2020. And he will be introducing his personal experience with the Singapore International Commercial Courts. And Justice Law, I'm now handing over the floor to you.
Thank you. Mr. Chairman, distinguished speakers, guests, and participants, ladies and gentlemen, good afternoon. Thank you for inviting me to say a few words at your international conference. It's indeed a great honor. And it's also a great pleasure, as I know quite a number of you, including you, Mr. Chairman, as I believe we met in the Supreme Court chambers before. So let me begin by informing you that all our courts in Singapore use an integrated electronic filing and litigation system, which we call E for that word echo dash lit, LIT. It's a fully integrated electronic system, which we set up in 2013. The precursor was set up in the late 1990s, and we have improved on that system. So we use open standards and functionality delivered through commonly used browsers like Microsoft Internet Explorer, Firefox, Google Chrome, and it's accessible to law firms and service bureaus and others who need to do court filings. This system enables all court documents to be prepared and filed electronically. And it enables us to conduct hearings today by video conferencing. And it can be, all documents that are filed in court can be accessed during the hearing. In Singapore, proceedings are commenced by the service of originating process. That means we serve the writ or the originating summons on another party. And in the International Commercial Court, which I shall call the SICC, this is seldom a problem because most dispute resolution clauses have identified a person on whom process can be served. So the plaintiff commences his action by using the e-lit service and filing his claim, and then serves this electronically on the defendant through the e-lit system. In the unusual case where there is no dispute resolution clause, then we have our rules of court, which allow you to serve it where there's a civil service procedure convention by using that convention, but we only have this applicable to Austria, Italy, Germany, and the People's Republic of China. Second way we can do it, if we don't have a civil service procedure convention, is through the government of the country, foreign country, if the government is willing to effect service. Next, through the judicial authority of the foreign country, if that authority is willing to effect service. Next, through a Singapore consular authority, or lastly, according to any manner permitted by law. In many cases, many countries allow us to effect service through law firms in that country. I just add a note that we are not a party to the Hague Convention on the Service Abroad of Judicial Documents. I don't know why this is so, but this is in the purview of the government, the Ministry of Law, and not the courts. So who can use the e-lit service? Any lawyer can do it who is in Singapore. A registered foreign lawyer from abroad, registered in Singapore, can do it. Or lawyers can apply for an e-lit account to use this system. As the last speaker said, it's important that laypersons can be able to use it. So we also have service bureaus in Singapore and LawNet, which enable the laypersons to use it. So generally speaking, as I've said, all documents used in litigation, whether it be affidavits, pleadings, applications, writs, are all filed through the e-lit system, and they are electronically served on the other parties. Since the COVID-19 pandemic, all our courts have, with very few exceptions, conducted our hearings through video links, and judges and counsel appear on screens, and documents are all managed and presented on the monitors. The only reason why we may not have a video conference hearing is if it's in the serious criminal cases where the penalties are quite high. So let me come back to the electronic hearing. We can dial in, who can dial into the hearing is strictly controlled by an assistant registrar of the Supreme Court or the judge's judicial clerk. Only authorized persons can appear. And it is important we stress, just like I did here, for dry runs to be held to ensure that the video equipment is compatible. It is important for the smooth operation of trials that the witness protocol is established and agreed to by the parties. And this includes, for example, who can be in the room with the witness, how the witness is referred to documents, and to ensure there's no one there to help prompt the witness. This also includes arrangements for translation. We often, through case management, ask counsel to agree this before the hearing so we do not run into trouble or interruptions. During the trials, all documents can be accessed by the parties. And just as a lawyer or a common service provider like Epic can call up a document as you are seeing on the screen now, judges, counsel, and third service providers can do so. A word of caution, when you're taking evidence in a foreign jurisdiction, I think the courts and counsel should check that the taking of evidence on oath of a witness in that foreign country is not prohibited. We have checked through the Hague questions that were administered, and there are a number of countries that do not allow foreign courts to take evidence on their own jurisdictions. This includes China, Germany, Korea, and Japan. So we also ask lawyers to check before they ask us to connect to a witness in a foreign country that foreign country does not prohibit taking of such evidence. I'm almost coming up to 7 minutes, and I think I've covered most of what I want to say, that in Singapore now, COVID-19 has accelerated the way we hear our cases. They are basically all heard electronically and online and through monitors. We seldom have physical hearings anymore. Thank you.
Thank you, Justice Law, for sharing your valuable experience with the SICC and also Singapore courts in general. We now have the final panelist, Ms. Joo-hyung Lee from the Korean National Court Administration of the Korean Supreme Court. Ms. Lee is Director of International Affairs at the Supreme Court in Korea. In this capacity, she is in charge of various international affairs, including international judicial assistance in civil matters, management of a training program for developing countries, support of regular communication with the foreign judiciaries, assistance in international legal symposium, and activities of a working group on international law at the Supreme Court. She will be introducing the Korean court practice in relation to the Hague Service Convention, and I'll hand over the floor to Ms. Lee, please.
Thank you, Chairperson. First of all, let me express sincere gratitude to Judicial Policy Research Institute for organizing this meaningful event. Thank you very much indeed for informative presentation of two speakers and sharing us your insights on e-service and the Hague Service Convention and International Commercial Court and electronic litigation. It is a great honor for me to be invited here to participate in this session on this very timely issue. Current pandemic has changed or rushed us to change traditional judicial procedures or practices. Considering recent trend of social distancing due to COVID-19, it is truly obvious that it is the perfect timing to actively introduce digital technology to our judicial system so as to narrow the social gap and to ensure access to justice during pandemic. As the chairperson already provided the brief introduction, I'm a director of the International Affairs of the National Court Administration. National Court Administration plays a critical role in international judicial assistance since it is designated as central authority under the Hague Service Convention. I would like to take this opportunity to share current practices, particularly recent trend during pandemic, of cross-border service of documentation first, add some comments from the technical point of view focusing on the e-service second, and lastly, raise some questions to our distinguished speakers if the time allows. Before directly moving to the part of service practice, let me briefly refer to the history of Hague Service Convention in Korea. Republic of Korea began to participate in Hague Conference as an observer state in 1996 and formally joined next year in 1997. With regard to Service Convention, after approval of ratification bill at the National Assembly in 1999, it entered into force in 2000. In addition, 5 bilateral mutual assistance treaties on civil and commercial matters are already in force with China, Australia, Mongolia, Thailand, and Uzbekistan. Since then, International Affairs Division has had more than 2 decade history and experience in implementing Service Convention as a designated central authority. We have 3 staffs with all-round expertise and on-site experience who are dedicated to assist all the service documents in and out. Our team is busy coping with many inquiries not only from domestic courts, but also from central authorities of other contracting parties and related interested parties around the world. This table shows statistics of international judicial assistance in recent 5 years. Please be noted that these numbers on the table are covering services not only under Hague Service Convention, but also other bilateral judicial assistance treaties, domestic laws, and services in accordance with reciprocity principle. Interestingly enough, the number of the requesting are almost 4 times larger than requested, since Korean courts are more active in making use of this multilateral tool. Our team takes charge of around 5,000 cases in total per year. Requests related to criminal matters are included in this table as well, which are delivered through Ministry of Justice, but only very small proportion, approximately below 10%, however. Most of the requesting and requested documentation includes petition, notification of date, and notification of the change in parties to a suit, decision of cost on litigation, notification of executive order, and so on. The purposes of most of the requests are subject to family matters such as petition for divorce, suit for confirmation of existence of biological parental relation. Lawsuits for refund of price of the goods are the main contents of the request as well from the commercial matter perspective. But you'll find more dramatic change in complexion, specifically increase of the service abroad on these graphs. 2000 is the year of entry into force of Hague Convention in Korea, and the initial number of requesting was 100, and the number of requested was 55 respectively. But in 2008 to 2019, the number is skyrocketed almost in 10 times to around requesting 1,000 and requested approximately 500 respectively. Having said that, services were affected by the COVID-19 from the beginning of this year. On the very right side of this graph shows the sharp decrease of service below 500 cases. Transmission from one contracting party to another is almost completely blocked at first this year, but the situation gets better in summer. But still, according to the recent announcement by the Korean authorities, regular mailing service to Italy, Uzbekistan, Israel, Laos, most of the Central and Southern American countries, including Mexico, Chile, Ecuador, Panama, Jamaica, were blocked. Even worse, we also face delay of the service to China, Singapore, Poland, Vietnam, UAE, etc., due to flight suspension or reduction. The same difficulties are also located in diplomatic channels as well, because diplomatic pouches are also delivered through general postal service. Furthermore, even though the postal service would be able to operate it across the border, it is highly likely that the delay of the domestic postal service is inevitable due to current situation. Considering all above, COVID-19 would definitely accelerate the need for e-service in order to avoid these current obstacles. But even before pandemic, many states have introduced domestic rules and regulations to allow e-service at a domestic level. And for example, the Act on the Use of Electronic Documents in Civil Litigation enables e-service upon the permit of the litigants in Korea. Practical use of international commercial courts at a regional or international level also depends on the availability of e-litigation and e-service system for sure. However, let me address 2 points we need to consider in advance on e-service abroad. First of all, there should be a soft landing of this high-end solution particularly for developing parties. The digital divide among the contracting parties would undermine the possibility to fully implement a service under the multilateral fora. In practice, a slight discrepancy in translation, for example, sometimes lead to a rejection of the requesting of the service of the documentation, even from developing countries. Many developing countries still face difficulties in various aspects. Therefore, we should actively launch capacity building for sharing of information platform for e-service domestic legislation or the model law on e-service, for instance. Second, in case we endeavor to introduce e-service abroad, we need to consider that the minimum level of consistency of the e-service legislation should be considered from a domestic to international level due to security issues or the legal certainty. Many countries have already developed domestic laws and practices on e-services, but they are still reluctant to accept e-service abroad for various reasons. I believe it seems quite clear that the digital technology would pave the way to secure legal certainty and authenticity of documents at the end. But aiming at this objective, we need to cooperate among parties ensuring security, standard of security technology, and so on. If the time allows, may I raise some questions to our distinguished speakers? My first question goes to Mr. Brody Warren. I'm wondering whether the HCCH Secretary is considering to launch any supporting project to tackle current pandemic and smoothly implement Hague Service Convention to contracting parties recently. And I also want to raise questions to Dr. Kim. Dr. Kim explained briefly at the end of his presentation that there will be some possibility to accept very high-end technologies such as blockchain to the e-litigation system in the International Commercial Court. But is there any disadvantage to introduce this high-end technology such as blockchain? Thank you very much for your attention.
Thank you, Ms. Lee, for your very excellent presentation on the Korean court practice on under Hague Service Convention, including electronic service aspect. Ms. Lee raised 2 questions to each of the 2 speakers, and probably the speakers would already have heard from her, from Ms. Lee, of the question. And if Mr. Warren is still there, would you address the first question raised by Ms. Lee?
And thank you to Director Lee for the question. I think the first thing to mention is that at this point in time, we don't have a specific project launched to as she mentioned, to assist authorities and contracting parties with the operation of the convention, specifically in the pandemic. That being said, I think at the Permanent Bureau, we are certainly actively engaged with a number of different authorities to help them kind of combat the challenges that have arisen. Even prior to the pandemic, we were already conducting work into the use of information technology, IT, with the contracting parties to both the service and evidence conventions. And I think that's where we would certainly continue to encourage the development of both legislation and also resources and capacity to allow electronic means to sort of flourish and to be able to be used under both the service and evidence conventions. And I think at this point in time, it's certainly something that we will continue to engage with the states themselves. And perhaps eventually there may be something that's more a broader kind of project to facilitate or support that. But I can only say at this point in time, we remain open to discussing these kind of options and encouraging states to continue developing their systems so that we can continue to ensure the effective operation of the convention, even despite the challenges imposed by the pandemic.
Thank you, Mr. Warren. It seems that effort should be made on a continuous basis. And Dr. Kim, would you address the question raised by Ms. Kim about the new technology such as blockchain?
Thank you, Director Chu Hyung Lee, for your kind comment and questions. I think blockchain technology is not a kind of ready-made solution to the system because blockchain technology is still underdeveloping technology. So I think it may be a solution, but it is not it's not a kind of ready-made solution. So I think it is underdeveloping and more research is still going on to the topic. Thank you.
Thank you, Dr. Kim, for your comment. I know that the time is already over for our session, and and I have checked if there was any question from the floor, but there's none. So this concludes our session, and thank you very much for your attention.
Yeah, thank you. It was such instructive and informative presentations and discussions. Please give all participants of the session 4 a big round of applause once again. This brings to the end of the session 4, and now we'll take a 5-minute break now, and we'll reconvene at 3:25 p.m. Thank you. Distinguished guests, we're soon starting session 5, so for those who are outside the conference room, please come into the conference room and take your seats. Now, I would like to invite the moderators, speakers, and panelists of the session 5 to proceed to the stage. Thank you. 내외 귀빈 여러분, 안내 말씀드리겠습니다. 제5세션이 곧 시작될 예정이오니 행사장 밖에 있는 분들은 조속히 안으로 입장하셔서 자리에 착석해 주시기를 부탁드립니다. 그리고 제5세션의 사회자, 발표자, 토론자들께서는 단상 앞으로 나오셔서 지정된 좌석에 앉아주시기를 바랍니다. 감사합니다. Ladies and gentlemen, now we'll commence the session 5. I would like to begin session 5 with a greeting speech of Honorable Secretary of UNCITRAL, Ms. Anna Jubin-Bray. As Secretary Jubin-Bray wasn't able to attend today's conference, she kindly sent the video message. Please look at the screen. Thank you.
Greetings from Vienna. President of the JPRI, the Judicial Policy Research Institute, Ki-tae Hong, my dear friend and colleague, the Secretary General of the Hague Conference, Christophe Bernasconi, my also dear friend and colleague, the Secretary General of UNIDROIT, Ignacio Tirado, distinguished speakers and panelists, esteemed guests. Greetings from the United Nations Commission on International Trade Law, UNCITRAL, in Vienna. It's my honor to open today's session on the enforcement of arbitral awards and of settlement agreements resulting from mediation that will be moderated by my colleague Atita Kominder, the head of the UNCITRAL Regional Center for Asia and the Pacific, RCAP, in my stead. I would have loved to be joining you in person, and until the last moment we were making arrangement for it to happen. Unfortunately, a new wave of COVID-19 cases in Austria, as well as the disruptions that the COVID-19 pandemic is bringing to the United Nations General Assembly committee meetings and planning, will have prevented me from being here with you in person. I'm, however, very pleased to be addressing you virtually, and thank you for your understanding. With the current circumstances brought by the pandemic, UNCITRAL texts and work on international dispute settlement has become more important than ever. I'm therefore very pleased that today's expert panel will be discussing the New York Convention and the Singapore Convention in Mediation in tandem. Having celebrated its 60th anniversary last year, and with near universal participation by 166 states, with Sierra Leone having deposited its instruments of ratification just 2 days ago, the New York Convention provides common legislative standards for the recognition of arbitral agreements and recognition and enforcement of foreign arbitral awards, subject to only specific limited exceptions, and thus facilitates the resolution of disputes globally. Its uniform interpretation is critical to its success, ensuring that it has the intended certainty and legal predictability across all jurisdictions, which is why Yas Banifatemi's presentation on the Ancestral Secretariat Guide on the New York Convention is its frequently referenced online platform, NewYorkConvention1958.org, the largest bibliography ever consolidated on the convention, is most welcome. It is our hope and expectation that the Singapore Convention on Mediation will rise to the position and importance that the New York Convention, the cornerstone of the arbitration system, has achieved on arbitration. On 12 September 2020, the Singapore Convention entered into force. This occurred just a little over 1 year after the convention opened for signature on 7 August 2019, and this is a remarkable achievement. We're very fortunate to be joined today by Nathalie Morris-Sharma, the chair of the Ancestral Working Group that negotiated and prepared the convention and accompanying model law. There are currently 6 state parties that have ratified the convention and 53 signatories, including the Republic of Korea. While the success achieved thus far is truly extraordinary, it's equally worth noting that for the convention to reach its full potential and effect, we must continue our efforts and invite more states to ratify and accede to the convention. I also welcome our distinguished discussants, Professors Jung-Ji Kim and Kyung-Jin Choi, both of whom are long-standing friends of Ancestral, who will enliven the discussion and the session with their expertise. Ancestral's work of course continues. Experts in previous sessions discussed Ancestral's ongoing work on the progressive harmonization and modernization of international commercial contracts, secure transactions, and insolvency, and today's final plenary session includes updates on Ancestral's development in dispute settlement and the Asia-Pacific region from our colleague Jae-Sung Lee, the Secretary of Working Group 2, and from Atita Komindir and the Ancestral RCAP team. With special thanks to our co-organizers, JPRI, the Hague Conference, and UniDroit, and the event sponsors, I leave you in the best of hands of my colleagues and wish you a very engaging and productive session. Thank you very much.
Thank you. In session 5, we will address enforcement of arbitral awards and settlement agreements resulting from mediation. It is a great honor for me to introduce the moderator of this session. The moderator of this session is Ms. Athita Kominder, the head of the Ancestral Regional Center for Asia and the Pacific. Admitted to the New York Bar since 2002, Ms. Kominder has experiences in both common and civil law transitions in the public and private sectors and holds degrees from Harvard College, Georgetown University Law Center, and Harvard Law School. She has over a decade of experiences in the fields of international trade and economic law, arbitration, multilateral dispute resolution, and the rule of law and its developments. Prior to joining the United Nations, she mainly advised and worked with numerous Thai agencies, including the Thai Institute of Justice, the Thai Ministry of Science and Technology, and Thai Arbitration Center, and the Thai Ministry of Commerce. Now, I would like to turn over the floor to Ms. Kominder.
Thank you very much for that kind introduction. Good afternoon, everyone. I am very honored to be moderating this segment, of whom the majority of participants, although you cannot see them, are actually female, which positively indicates to me the growing diversity in international dispute resolution. I am also delighted that all participants are friends of UNCITRAL who have collaborated with us in different contexts multiple times over the years. Thank you for that. In her greeting, Anna has thoughtfully foreshadowed our speakers' presentations, so it remains to me to introduce them. Now, first up among our speakers is Yaz Banifatemi, who is Sherman Sterling's Global International Arbitration Practice Group Leader. She also serves as the firm's Public International Law Team Leader and Energy Industry Leader. Yaz is widely recognized as one of the most prominent international arbitration and public international law specialists worldwide. She acts as counsel and arbitrator. She's a vice president of the ICC International Court of Arbitration, a member of SIAC Court of Arbitration, and a former member of LCIA Court. Yaz is also a member of the ICSID panel of arbitrators, appointed by the chairman of ICSID's Administrative Council. Yaz also teaches at Harvard Law School, Yale Law, and Panthéon-Sorbonne University. She has authored numerous publications on international arbitration and public international law issues, and frequently speaks on them as well, which is why she is with us today. So Yaz, I hope you are connected. Bonjour et bienvenue, and the next 20 minutes are yours. We cannot hear you. Are you muted? No. No, we can't hear you.
Do you hear me now?
Yes, we hear you.
Okay. So good afternoon, everyone. It's a true delight to be with you today. As Anna mentioned, I will be discussing the UNCITRAL New York Convention Guide and its companion, the New York Convention 1958.org web platform. I will share my screen just to show you how this works. And I normally would have liked to do this live, but with the internet, it's never quite sure. So here you go. This is my presentation, and I will take you through it. So by way of a few introductory remarks, I wanted to simply refer you back to 1958, when the New York Convention, which is a quite revolutionary instrument, was adopted on the recognition and enforcement of foreign arbitral awards. In 1958, when it was adopted, you had 24 signatory states, and you can see them on the map. And looking at and comparing this map with the next one, which is today, and as Anna mentioned, we today have 166 states bound by the New York Convention. It's a marvelous achievement and success. And you see that just in 2020, we have 5 new additions to the state parties to the convention, with Sierra Leone being the last one. Now, first, I want to discuss the UNCITRAL Secretariat Guide on the New York Convention. This comes from a long line of work and study and analysis by UNCITRAL, which started in 1969, where UNCITRAL really focused on the uniform interpretation of the convention, and focusing on that uniform interpretation, after a few decades, appointed in 2010 a group of experts to really work on this issue. And you have on screen in 2010 the mandate that UNCITRAL gave to its experts. The project should consist in the development of a guide with a view to promoting a uniform interpretation and application of the convention. It was considered that such a guide would assist with problems of legal uncertainty resulting from its imperfect or partial implementation, and could limit the risk that practices of states diverged from the spirit of the convention. So it's really truly with this mandate in mind, meaning looking at the way that the convention has been interpreted and applied in the state parties, that the two experts appointed by UNCITRAL started their work. And these two experts are Professor Emmanuel Gaillard, based in Paris, and Professor George Berman, based in New York. And the work started immediately in 2010 upon their appointment by UNCITRAL. The work itself took a number of years because this was a very thorough analysis of the case law in a number of countries, and I will come back to that. And the result, I want to immediately show you the result, is a UNCITRAL Secretariat guide in all 6 languages of the UN, which is available on the website. I will show it to you in a moment. And you also have hardcover copies in both French and English that are available to purchase. Now, the method, and this is truly important, the methodology was that the research teams initially identified and analyzed the case law from 15 countries, and this is a mix of common law and civil law jurisdictions. You see them on screen. These are, to some extent, the countries that have the most established practice in arbitration, and of course in the application of the New York Convention itself. We started with 15 common law. I have to say that I was the head of the research team. I still am, because this is an ongoing project. And we have gone from 15 jurisdictions to 45, which is the number of countries that were looked at when the UNCITRAL guide was later on published. And you see that, and this is the very important point to make, the extensive case law analysis that uncovered the key trends was based on a bottom-up approach. This was extremely important to both the teams, the research teams, and UNCITRAL itself, meaning that we looked at what the case law says. There was no preconceived notion of what the uniform interpretation should be or what the application should be. It's really looking at the case law of these countries that we were able to analyze and to identify common trends, and really how all jurisdictions are applying and interpreting the convention. And I will show in a moment our conclusions. And the guide, as you will see on the website, is freely accessible, includes a chapter for each article of the convention, and it also includes the preparatory works and, of course, a selection and excerpts from the relevant case law in the countries that were analyzed. And I will show it to you in a moment. This has led to also the creation of the New York Convention 1958.org, which is the companion of the guide and which is being kept up to date on a permanent basis. And this is the case law reference in the guide. I have to insist that these are the jurisdictions that appear in the guide, because this was the first work. And at the same time, the website itself is much more up to date, and the guide itself will also become up to date based on the most recent work that we have accomplished with additional jurisdictions. So we started, and I will show you in a moment the number of countries we currently have with the help of contributors. I have to say that we could not have done this without our contributors, which include a number of institutions, including arbitral institutions, a number of courts around the globe, including the Supreme Courts of some of the member states, including, for example, when the New York Convention case law was difficult to find, which is the case for China, for example. And here the courts in Australia, Italy, China really helped us find, locate, and identify the relevant case law. The mandate, as you see, resulted in what is the UNCITRAL guide, and in the introduction of the guide, you can see again what the UNCITRAL wanted and what the mandate was, and what was important in the philosophy of the UNCITRAL. The purpose is to assist in the dissemination of information of the New York Convention and further promote its adoption, as well as its uniform interpretation and effective implementation. And this is truly important as well. The guide is meant to help judges, arbitrators, practitioners, academics, and government officials when they use the case law and use it more efficiently. And now just a few words on the conclusions, because this is truly important, based on the analysis that was conducted in all of these jurisdictions. experts arrived at the conclusions that the courts around the world apply the provisions in a consistent manner and promote the Convention's objective to facilitate the recognition and enforcement of arbitral awards. This is truly important. And this, to some extent, came as a surprise to see such a consistent interpretation and application of the Convention. The second conclusion was that parties resisting enforcement have been largely unsuccessful at proving grounds for refusal of the recognition and enforcement under Article 5 of the Convention. And the third conclusion is that the Convention, and you see that also in the case law, sets a minimum standard, and national laws always can be more pro-enforcement. And this is reflected in Article 7 of the Convention, which provides for a ceiling or maximum level of control over recognition and enforcement, and on that basis, countries individually can be more pro-enforcement, which, for example, is the case for France. So these were the conclusions, and I want now to show you how the New York Convention 1958.org website functions. I'm not going to show it to you live, but this is what it looks like. This is the first page when you go to New York Convention 1958.org. You can see that there's a number of ways in which you can research the convention, and you see the box shows each entry, and I will show it briefly in a moment. A few figures that are very important. So today we have over 70 countries represented on the website, including Korea. We have case summaries of over 800 cases. We have over 3,600 original language decisions on the website, and these has been the result of an extremely hard work. We have tried to get a case law that is available or sometimes not available, and we have put it freely available on the website. You have over 1,000 references in bibliography about the New York Convention, over 100 translations into English, and this is work in progress. And last but not least, this is a fully searchable content, and I will show you in a moment how this works. But the most important part is really that this is all freely accessible. There's you do not have to pay. You just have to type New York Convention 1958.org, and you have access to the entirety of the information on the website. So very briefly, how this works, you can access through the guide itself, and the guide itself, you can see it either in HTML version or in the PDF form in the 6 languages of the UN, as you can see it on screen. When you look at the HTML version, I'm taking the Article 7 example. You can see that you have the provision itself, and then scrolling down, you have the guide, the section of the guide on Article 7, since this is my example. And each time you have a freely accessible case or doctrinal work, you have that on the website with a link to that the decision or to that article. Here, for example, Professor Gaillard's article on the urgency of not revising the New York Convention, which was a speech based on a speech given in Dublin at ICA. And scrolling down further, for example, if there's travaux préparatoires, the negotiating history of the convention on Article 7, for example, you also have it freely accessible, and you have a link here, and it can take you directly to that. You can also access the website through the case law. And as you can see, there's 3,659 decisions currently on the website. This is kept up to date permanently at all points in time. I will come back to that in a moment. You can also go through the convention itself. So you have, again, access to the provision, and here again, Article 7, and you can see the provision, the case law relevant to that provision, and the travaux préparatoires relevant to that provision. Of course, you can also enter through the signatories map, and here you have the signatory map page. And then on the basis of that, you can enter each of the jurisdictions that are bound. And for now, we have 70 jurisdictions, as I mentioned, including Korea. And just to say a few words, and as you can see, the last countries, Ethiopia, Sierra Leone, Tonga, Palau, and Seychelles are the ones having just joined. So Korea, a few words on Korea. I have to thank our contributors from Bae, Kim, and Lee. Woo Jae Kim, Hyusing Bang and Hyesung Jeong, they helped us prepare this page for Korea. So you have a first introductory page on essentially everything you need to know about the New York Convention in Korea and how it has been adopted, accessed, or ratified or applied. And then when you go further on the page, you can see the case law in Korea, the travaux préparatoires relevant to Korea, and of course in library, the references in relation to the New York Convention and Korea. So just to show you how this works, if you look at the case law in relation to Korea, you have currently 31 decisions that are on the website. And you can see that if you take one, you can actually refine. You see that you can refine by type of court, by provision, or by year. And each decision, here I'm showing you one decision. The first one, for example, you enter into the decision page and you have the relevant provisions of the New York Convention that are discussed, and you have the original language. And this is something that we have insisted doing. You always put the original language when it's available on the website, and you see that you have access to it in Korean, and you can actually do a search in the document in Korean. And this is also a very relevant and welcome technology that we're using. And now to the library, we have over 1,000 documents that you can look on the website. These are all articles and books that are relevant and discuss the New York Convention and its application. And again, when you have a article, for example, that is either available and we have put it on the website, or you can have access to it through an external resource, and you have the link to that external resource. The last is the travaux préparatoires. Of course, if people are interested in looking at the negotiating history, you have also a page on the negotiating history, which was provided to us, of course, by UNCITRAL. Last but not least is the search engine, which is an extremely powerful search engine. You can really do a search by keyword, nothing more, but you can refine by type of document, case law, jurisdiction, doctrine. You can do a search also refining by provision type or by country. So giving you one example, if you look at the Cromalloy decision, for example, and you wonder how Cromalloy was looked at in India, in the case law of India, you can do that. And for example, you can see that here we have two results, two documents, and these are the cases in India, in the Indian case law. And you can, of course, look at that, and it takes you to the case, and you see on top, it refers you to Cromalloy and where decision Cromalloy is discussed. And on the bottom left, you can see that you can scroll directly to the next time when it is discussed. I want again to thank our contributors, but we are always open to have new contributors for the jurisdictions we're not covering. So this is also a call for contribution to everyone. And using technology, we also are on LinkedIn. So this is show you the LinkedIn page of the New York Convention Guide. You can follow us, and we give everything that concerns the New York Convention immediately as soon as there's news. We give that. Two more remarks before I end. I wanted to really highlight that the New York Convention Guide is totally in line with the 2030 Agenda for Sustainable Development of the UN, in particular Goal 16. And you see that with this website and the UNCITRAL website, UNCITRAL Guide itself, we are helping the promotion of the rule of law with equal access to justice for all, because the website is completely open and free, accessible to anyone having an internet anywhere in the world. It's inclusive of all decision making, it's publicly accessible, and of course it allows participation of developing countries as well. And you can see, and again, just to remind you, the link, New York Convention 1958.org, and this guide, the New York Convention Guide, has been recognized and is referenced in the case law of different countries. I want to show a few examples. The Supreme Court of India has been referring to the UNCITRAL Secretariat Guide. If you look at England and Wales, the High Court has done the same. If you look at Pakistan, the High Court of Lahore. If you look at the Federal Tribunal in Switzerland, also having recognized and referenced the guide. and also Sweden, the Supreme Court of Sweden has done the same, and you have a number of other courts around the world having also referenced the guide, and really recognizing the strength of this guide in that it shows it shows how the New York Convention is truly uniformly applied across the globe in a universal manner. And this is the strength both of the convention and of this website. These are my remarks, and I will be very happy to take questions and remarks later on. Thank you very much, everyone.
So thank you very much to Yaz for that informative and interesting and high-tech presentation. We will discuss her presentation later, but before that, I will now turn to our second speaker, Natalie Morashama, who is Deputy Senior State Counsel with the International Law Department of Singapore's Attorney General's Chambers. She served in various capacities, including as Director of the International Legal Division of Singapore's Ministry of Law and as Legal Advisor to Singapore's permanent mission to the United Nations in New York. Natalie has also participated in and led several international negotiations, including chairing the UNCITRAL working group that developed the Singapore Convention on Mediation, as Anna had mentioned. And she currently serves as Rapporteur of UNCITRAL Working Group 3 on Investor-State Dispute Settlement Reform. Natalie has also published on topics relating to various aspects of international law and studied at University of Cambridge and also NYU, obtaining her LLM there, and is called to the bar in New York and Singapore. Natalie, very nice to see you. We've seen each other many, many times in many, many forums over, I guess, these past months. So happy to see you again. And please, the floor is yours. Thank you.
Very much, Afita. A very good morning, afternoon, and evening to everyone. Thank you to the organizers for inviting me to be a part of this conference. Regretfully, I'm not able to be in Korea right now, but it is good to have the opportunity to continue to engage with you via virtual means. My presentation today seeks to introduce to you another one of UNCITRAL's recent outputs, a treaty that is known as the Singapore Convention on Mediation. I will first give a brief overview of the history of the development of the convention before speaking about its key provisions, and I will then wrap with brief concluding remarks. With that, I will now share my screen. The Singapore Convention on Mediation was developed in parallel with amendments to the Model Law on Mediation. And the United States had put the proposal of the convention on the table in 2014. The text was finalized and adopted in 2018. And although it was really only in February 2018, as part of a compromise proposal, that we knew that we were going to be able to proceed with having a convention. As Anna mentioned in her remarks earlier, the convention opened for signature in Singapore on 7th of August 2019, and already the convention has been signed by 53 countries from all regions of the world, including the Republic of Korea, which had signed on the day the convention opened for signature. It's also been ratified by 6 countries and will enter into force on 12th of September, or rather has already entered into force earlier this year on 12th September 2020. The Singapore Convention was developed in response to the lack of a cross-border mechanism giving legal effect to international mediated settlement agreements. And this was said to be a significant barrier to the use of mediation to resolve disputes. Currently, disputing parties that reach a mediated settlement agreement generally already seek to convert their settlement agreement for enforcement purposes into other forms, such as a consent award. And this is in order to be able to utilize the network of parties to the New York Convention. But as we know, there are inherent uncertainties in this approach. For instance, if an arbitration is only commenced after the parties have reached a settlement, in many jurisdictions, the resulting award would not be one that settled differences between the parties and therefore would not fall within the scope of the New York Convention. So this is where the Singapore Convention comes in. The Singapore Convention was modeled after the New York Convention and will be to mediated settlement agreements what the New York Convention is to arbitral awards. The convention recognizes that with a mediated process, the settlement agreement is not a mere contract, And so long as the requirements of the convention are met, mediated settlement agreements can benefit from the convention's recognition and enforcement framework and the ensuing certainty. So moving on to the key provisions of the Singapore Convention. In terms of the scope of application, the Singapore Convention applies to international, commercial, settlement agreements resulting from mediation. A few comments on each of these elements. Of note is the fact that the criterion of internationality applies to the settlement agreement and not the agreement to mediate. Unlike the New York Convention, there is no reference in the Singapore Convention to foreign mediated settlement agreements, as there is no concept of a seat in the mediation the way you would have with an arbitration. The term commercial is not defined in the Singapore Convention. However, it is to be broadly understood. The Convention does, however, stipulate that consumer issues or family, inheritance, or employment law matters are excluded from the scope. Another exclusion is in relation to agreements approved or recorded as judgments or arbitral awards. The Singapore Convention does not apply to settlement agreements that have been approved by a court or were concluded in the course of proceedings before a court and that are possible of being enforced as a judgment in the state of that court. It also does not apply to settlement agreements that have been recorded and are possible of being enforced as an arbitral award. Now, these exclusions were incorporated to address concerns over overlap or gaps in the enforcement regimes of judgments, arbitral awards, and mediated settlement agreements. And specifically, the purpose was to avoid overlaps or gaps between the Singapore Convention on Mediation on the one hand, and the Hague Conventions on Court Judgments, as well as the New York Convention on the other hand. As for the definition of mediation, you will note from the definition that is set out on the slide that it is defined broadly. And this is to enable the definition to accommodate mediation as a flexible process. There is also no limitation on the types of remedies that can be reflected in the settlement agreement. Amongst others, it can include monetary or non-monetary elements. This is quite critical because it recognizes that in a mediation, your disputing parties are able to design a settlement that responds to their needs. This takes a holistic view of their interests and commercial relationship. The next slide is on the general principles as reflected in the Singapore Convention on Mediation. Under the framework for the cross-border enforcement that is established by the Singapore Convention, parties to the convention would continue to apply their own rules of procedure. And in framing the general principles of the convention, we already had to contend with different practices and understandings across various jurisdictions, and this necessitated a rather creative approach, if I might say, towards the articulation of the general principles. So you will not see the term recognition and enforcement, which you would be familiar with from the New York Convention. This does not appear in the Singapore Convention. Instead, the concept of recognition and enforcement is articulated in functional terms, whereby a settlement agreement may be enforced or invoked. Enforced as a sword, so that the obligations in a settlement agreement are carried out, or invoked as a shield to prove that the matter has already been resolved. The form requirements are intentionally simple and straightforward. Essentially, the convention may apply so long as the settlement agreement is in writing, signed by the parties, and so long as there is evidence that the settlement agreement resulted from mediation, which evidence can be provided by a number of different methods, as enumerated in the open list in the convention. It is important to note that when the Singapore Convention was being negotiated, we recognized that it was not appropriate in some legal cultures to have a requirement that the mediator sign the settlement agreement, as this could, and for this to be the only acceptable proof that the agreement had resulted from mediation. So this is why the types of proof that the convention provides for is reflected in an open list. Turning quickly on to the grounds for refusal. The grounds for refusal are limited to those that are set out in the convention, and they include where there was incapacity of a party to the settlement agreement, if the settlement agreement was null and void, for instance, because of fraud or misrepresentation. And the grounds of refusal are also tailored to the practice of mediation. The idea here was to retain the successful elements of the New York Convention while responding to the difficulties posed by seeking to translate the grounds of refusal of enforcement in the New York Convention to the mediation context. So some examples would be excess of authority in the New York Convention's 5.1c and procedural irregularities in Article 5.1d of the New York Convention, which do not immediately transfer into the mediation context in a comfortable fashion. It's almost like a square peg in a round hole situation. Grounds E and F, which are set out on this slide, are specific grounds pertaining to mediator misconduct. These grounds of refusal, I should highlight, were some of the most difficult issues that we had to deal with when drafting the convention, and they were extensively negotiated. In its final form, the enforcement of mediated settlement agreements may be refused where there was a failure to disclose on the part of the mediator which had a causal effect on the disputing party entering into the settlement agreement. And the intention is for the ground of refusal to apply only in exceptional circumstances. Nobody doubted during the negotiations the importance of ethics or the significant role that mediators play in enabling a settlement agreement to be reached. The issue, and what made it so difficult, was whether there should be these situations should be the subject of specific defenses or could be addressed by other grounds of refusal, such as the settlement agreement being null and void or for reasons of public policy. We also had to ensure when we drafted the provisions that objective terms were used and that these terms could be understood in different legal traditions. And this was to minimize the risk of opening the door to satellite litigation. The focus in the grounds of refusal here, therefore, is where the disputing party's agreement to the settlement was vitiated by mediator misconduct. The last point on the slide regarding Article 5.2, those are similar to the grounds of refusal that you'll find in the New York Convention, and so in the interest of time, I won't be elaborating on them, but rather move on to my next point on the reservations. This is the final key provision of the Singapore Convention that I will cover today. 2 reservations are permitted under the Singapore Convention, and these relate to the application to agencies of governments, as well as to whether the disputing parties need to opt in for the convention to apply instead of the default out. So in the first instance of the declaration regarding government agencies, a party, so a signatory state or a party to the convention, may declare that it shall not apply the convention to settlement agreements to which it or its agencies or agents is a party to the extent specified in the declaration. Now, this reservation was included in the Singapore Convention in response to a suggestion made during the negotiations to exclude all settlement agreements involving government entities from the scope of the instrument. And this suggestion came about because in some jurisdictions, government entities were not authorized to conclude such agreements. But the general view in the negotiations was that a blanket exclusion of settlement agreements would not be desirable. Government entities, as we are aware, do engage in commercial activities. And so accordingly, the Singapore Convention on Mediation does by default apply to settlement agreements involving government entities, except in the case where a reservation is made utilizing Article, I should apologize for the typo, it's Article 8.1a, then the convention would not apply to the extent stated in the reservation. The second reservation is in relation to Article 8.1b, and this concerns where a party may declare that it shall apply the convention only to the extent that the parties to the settlement agreement have agreed to the application of the convention. In gist, the convention applies for default, except where the parties to the settlement agreement opt out of it. And states can enter a reservation to apply the opposite rule, in other words. So for some delegations, requiring the disputing parties to expressly consent to the enforcement regime was a natural follow-through of the consensual nature of mediation. But for other delegations, requiring express consent would undermine the Singapore Convention's objective of promoting international commercial conciliation, as well as the ease of enforceability of mediated settlement agreements in commercial matters. Practically speaking, according to this side of the view, disputing parties would unlikely be interested in having further discussions regarding enforcement after they have reached their settlement agreement. And by that stage of the mediation process, rather, disputing parties would be more likely to have formed the expectation that the other party would comply with the settlement agreement that they had reached. So requiring an opt-in for the applicability of the enforcement regime would run counter to these expectations. The final landing point in the convention was to provide for this second reservation as a compromise. And it was an outcome that was seen as being facilitative of the maximal participation in the Singapore Convention while preserving its object and purpose. Before I wrap, I'd like to share some concluding remarks, and I will focus on maybe just two. The first concluding remark concerns the form of the instrument. For the bulk of the time that was spent negotiating the Singapore Convention on Mediation, we did not in fact have clarity regarding whether or not a convention would eventually be developed, or whether our work output would instead take the form of an amended model law, as views were divided in this regard. So what happened at UNCITRAL was the taking of an unprecedented step to develop both a convention as well as the amended model law in parallel with each other. And this understanding was reached as part of a package deal. One of the intentions behind the decision to concurrently prepare both instruments was to accommodate the different levels of mediation that different jurisdictions have with mediation. At the same time, what I want to highlight in particular is that because there was the concurrent development of these two instruments, there is therefore a high level of complementarity between the Singapore Convention on Mediation and the 2018 UNCITRAL Model Law on International Commercial Mediation, amending the UNCITRAL Model Law on International Commercial Conciliation 2002. Now that's the full title of the model law. So what this means is that the 2018 model law could be the means by which a party to the Singapore Convention implements the convention domestically. Hopefully this means that potential parties to the Singapore Convention have a smoother path towards joining the convention and implementing it. On what the Singapore Convention means for users of dispute resolution is my final parting remark for my presentation today. And in short, I think that the convention will make mediation a more meaningful, effective, and viable option for the resolution of international commercial disputes. It will broaden the suite of options available to users of dispute resolution, and depending on the subject matter of the dispute, the urgency of the situation, the relationship between the parties, and other factors, disputing parties may choose litigation, arbitration, mediation, or some combination of these to resolve their dispute, knowing that there will be certainty in the recognition and enforcement of the outcomes of the method of dispute resolution that is pursued, including if that method is by way of mediation. I think that the significance of such certainty cannot be overstated, and this has been brought to bear particularly in view of the world's experience with the COVID-19 pandemic, which has presented and will continue to present new uncertainties and challenges. Already we see that cross-border agreements cannot be carried out because COVID-19 has led to disputes between parties, or rather, cross-border agreements that cannot be carried out have led to disputes between the parties. And mediation has been touted as a good way to resolve such disputes. This additional factor, I think, is something to be taken into account in respect of the growth in interest in mediation, and will encourage users and hopefully states to see the value of signing and ratifying the Singapore Convention on Mediation, which, like the New York Convention, seeks to promote those broader principles of access to justice and the rule of law. Of course, as Anna mentioned during her remarks earlier, the mechanism that the Convention offers will be more effective and useful as more and more countries sign on and ratify it, joining Singapore and joining the Republic of Korea. And I certainly hope that more signatories and ratifications of the Singapore Convention are on the cards in the near future. Thank you.
Thank you very much, Natalie. I think your presentation and your virtual background were both out of this world, and I think it might perhaps subtly reflect our hope that the Singapore Convention is universally adopted. So thank you very much for that. I now turn to our first discussant, Professor Joong-Gi Kim, Hello, of Yonsei Law School in Seoul. Yoongi's treatise International Arbitration in Korea received the 11th Simdang International Trade and Business Research Award. He has acted as presiding sole and co-arbitrator in proceedings under the rules of a wide range of entities, including UNCITRAL. He sits on the editorial board of several international law journals and has been a visiting professor at several renowned institutions from all corners, such as Georgetown Law, KO, the National University of Singapore, and the University of Hong Kong. Yoongi will be posing some fascinating viewpoints and questions on what he has dubbed K-law. I hope that doesn't mean you'll be singing them, or maybe you will, and possible challenges related to the New York Convention's midlife crisis, again, interesting terminology, COVID, and then, of course, if there is time, ISDS, investor-state dispute settlement. So thank you, Jungi.
Thank you, Adita. It's a great pleasure to be here. And I'd like to thank, of course, our organizers. It's, of course, most unfortunate that Yaz is not be able to be here. I had the great pleasure to meet her, I think it was 2 years ago when she was in Seoul. And of course, we hope to welcome her next time. I'll just have some brief comments available. For those of you, of course, that might not be as attuned to the developments of the New York Convention, I thought I'd take a look at the flip side and see which countries have not signed the New York Convention. Of course, there are roughly actually 30 countries that have not signed the New York Convention. And of course, from our perspective here in Korea, the most prominent missing party, of course, is North Korea. And of course, the most interesting thing for me is, as a major development, is, of course, North Korea has signed CISG. But then why didn't they sign the New York Convention? I would think that, if anything, they should sign the New York Convention first. And I don't know, maybe I'm just biased. So I just thought that was so hopefully our friends in the North will be signing the New York Convention through Atita's hard work and efforts. And then I was looking at the other countries that have not signed the convention. And I was a bit surprised that actually there's some pretty significantly, in terms of mid-sized economies, that have not signed the convention. Probably the largest one is Iraq. And Iraq is actually a pretty big economy. And then Turkmenistan and Libya, notably. And then there are a good number of high-income countries, including St. Lucia, Grenada, and St. Kitts and Nevis. So there are a range of countries that we would expect would have signed but have not signed, and I'm sure they would be signing shortly. In terms of where Korea stands, many people outside of Korea don't know this, but Korea actually signed the New York Convention before Australia, before the UK, before Singapore, before China, and before Canada. And we should be very proud of this. And I would, as I'll talk about later, Korea has a very robust system, legal system, court system. We have a very strong rule of law, but the big problem for us is nobody knows about it. In terms of Yaz's work at the UNCITRAL Guide, we have to, of course, commend them for the tremendous efforts that they put into developing the guide. Unfortunately, of course, as we saw on that picture of all the flags, Korea's flag was not there in the initial investigation, but Korea is now, of course, included in the website. And there are many cases, and this is very notable. I was actually also thinking, though, that there probably are cases where the Korean courts have actually considered the guide, but they have not cited it. And I was, this is of course, so that was actually a very important reference, but if it's not cited, then it's not going to make it on the website and be cited by Yaz in the future. The only case that I'm aware of, actually, where a Korean court has done this is there's one high court case where a prominent Korean judge cited the travaux of the Unsitral model law. And that's the only case I'm aware of where this type of reference has been made. So to wrap up, there are several takeaways from Ya's presentation. And the first and most notable one for me is this development of what we call perhaps international common law. Or, of course, from an international law perspective, it's customary international law. So by taking this bottom-up approach, you have this wealth of case law across all jurisdictions, and they're interpreting their views on what the New York Convention means. And then over time, it'll be, I think, more and more difficult for a country to not think about this or not refer to it. And I think, of course, it's very important that many of those countries that Yaz has cited, that cited the guide in particular, were actually civil law countries. So I caught it was Sweden, Portugal, Slovenia, Netherlands, Belgium, and Colombia. All civil law countries, courts, have cited the guide. Of course, Korean courts are not as accustomed to this, that I think my view is, as I mentioned earlier, we have this very robust system, very rigorous system. Our judges are highly competent, fair, and independent, and sophisticated, but nobody knows about it. So I think what I was thinking about is one of JPRI's roles, and of course I don't want to add to their burden, but I think this is a matter of national pride, is to help kind of disseminate and export this knowledge about Korean cases and how they've interpreted the New York Convention, and to share this across other jurisdictions. And of course this could be done through the website. So as Atita kind of suggested, my view is we're very proud now of our K-pop, our K-beauty, our K-drama, and our K-food, but I think we should also be very proud of our K-law. We are exporting our laws, and I think this is one area where we could really export our case law as well. The final thing that I was going to wrap up with is challenges. Tita mentioned midlife crisis, but I don't look at it as a crisis. I just look at it as a challenge. Because I think the New York Convention is by far one of the most successful, short but powerfully successful conventions, treaties in international law. But it's 62 years old, and I'm getting there now. When you get older, things don't come as easy. Your eyesight starts getting dimmer. You get a little bit stiff. Don't sleep as well. I think these similar things are now showing up for the New York Convention. And the big question, therefore, is, as Yaz inferred slightly, is there's a big debate as to whether we need to revise the New York Convention. And then if so, some say yes. There's even a draft version of it by Professor Albert Jan Vandenberg. And then some say, no, it's not necessary. More to lose, not realistic, and no need. And maybe you'll just open up a Pandora's box. So the question is, facing these midlife challenges, is this the time to talking about it? And of course, the big context for us, from my world, where I actually am involved in these days, is from the investor-state perspective. There's tremendous discussion led by the work at Unsitral in trying to reform the investor-state dispute settlement system But is that going to influence, perhaps, revision of the New York Convention? And then, of course, we can also talk about the developments of technology. I think, if I remember correctly, the New York Convention still has the word telefax or something like that. Of course, that nobody uses that anymore, but technology has also a tremendous influence. So whether or not this will egg or push or lead to more discussion on this is my question for the future, and hopefully Yaz will have time to address it if she can. Thank you very much.
Thank you very much, Jungi. So while we give Yaz some time to reflect a bit on Jungi's personification of the New York Convention and its midlife crises, we will first turn to Professor Kyung-jin Choi, who received his doctorate from Sungkyukwon University in 2004 and has been a professor at Gachon University College of Law from 2007. He's currently Dean of the International Affairs Office and the Director of Center for AI Data and Policy at the university, and is also an arbitrator of the Korean Commercial Arbitration Board, KCAB, as well as a mediator of the Telecommunications Dispute Mediation Committee, Content Dispute Mediation Committee, and Personal Information Dispute Mediation Committee. So Kyung-jin will be discussing aspects of mediation and the Singapore Convention, including potential implications for South Korea, and if time is remaining, perhaps some dimensions on online mediation. So you have the floor.
Thank you, Atita. Good afternoon, everyone. Thank you so much for Natalie for explaining the meaning of content of the Singapore Convention on Mediation. Frankly speaking, I originally have prepared for several comments, but due to the time constraint, and then I would like to make a short 2 comments related to my questions. I would like to talk about the situation in Korea. When looking at the types of dispute resolution in Korea, mediation or arbitration other than trial is used in various disputes. However, in the case of mediation, it is hard to find an autonomous mediation system or procedure in the private sector other than mediation in court. Mediation in Korea is mainly governed by the administrative mediation system or procedures established by law. For example, there are various mediations for content disputes or telecommunications disputes or the environment disputes, etc., etc. Each law stipulates that a specialized mediation committee be established in the administrative department governing each specialized area. A number of laws governing mediations give the same effect as court settlement to the settlement agreement resulting from mediation. In other words, when mediation is established, it can be enforced through the court using the mediation agreement document signed by both parties. In particular, in most of the administrative mediation in Korea, the parties do not bear any cost burden. Professional mediation committees are established in the executive branch, but it consists of independent and neutral experts or lawyers. From this, quasi-judicial effect can be recognized under the law. Of course, the establishment of the mediation is based entirely on the agreement of the parties. Therefore, there are many cases where the people use the dispute mediation committees, which is fast, economical, and professional. On the other hand, unfortunately, it is difficult to find autonomous mediation procedures in the private sector. In particular, mediation for international commerce disputes is even more difficult to find. However, it is noteworthy that the Korea International Mediation Center was recently established in the private sector in Korea. On the other hand, the electronic mediation procedures are sometimes used in Korea. Korea is, as you know, is a leading country with a very high internet and ICT penetration rate. And its people's access to ICT is the best in the world. Utilizing this environment, there are cases in which applications for mediation to disputes resolution through mediation agreements are handled through an electronic system. In international trade disputes, it is very useful to have such an electronic dispute procedure and system, and it needs to be expanded in the future. Of course, the entire online mediation process may not match the nature of mediation itself, and where the process leading to concessions from mediation parties is important. Therefore, it is necessary to categorize these cases suitable for online mediation. Through this, it is possible to set a range in which electronic means can be used in the context of mediation. I have two questions to Natalie. First one is about, there are many government-led quasi-judicial mediation committees in Korea, as I said. So how effective do you think this Singapore Convention on mediation is under this Korean situation? And the second question is going to, is about the Singapore Convention recognizes the validity of the electronic communication in mediation agreement. Furthermore, I think that making the entire mediation process online can be useful for reasonable disputes between parties in different countries in international trade disputes. On the other hand, online mediation may act as a barrier to the parties' mediation agreement. In this context of the Singapore Convention, and how much do you think is possible and useful for online mediation other than electronic mediation agreements? Thank you.
Thank you very much to our two discussants. I think I will turn first to Yaz. Are you still with us? Maybe you could briefly address Jungi's questions.
Yes, I am. Do you hear me?
Yes, very clearly.
Thank you. So I thank you so much to Jungi for his comments, and thank you for reminding everyone that I do come to Korea and I love Korea, and I do hope to come back to Seoul in 2021 if things improve, hopefully. I have just a very few remarks, and I will come to Jungi's specific question. I did want to say that I do not want to take credit for, and Jungi very kindly referred to Yaz's work. I really want to insist that this is not my work. This has been a huge team, and I'm not responsible for the guide at all. This guide is an UNCITRAL guide drafted with the supervision of UNCITRAL by Professor Gaillard and Professor Berman. And I would like to in addition to being reputed professors and practitioners, they both come from two different backgrounds, civil law and common law, and you can see that there the different choices, including by UNCITRAL, really to look at the different systems of law around the world. And I do want, if you allow me, just to say one word to thank not only all of our contributors, all of the teams, but also today Pierre Viguier, who helps me maintain the site up to date every day, and Bénédicte Bodo, who actually helps me with the maintenance of the website. And it's true, and I do want to recognize everyone's work. One point on the Iraq, it's a very interesting point by Jungi. It's true that some states are still needed, but at the same time, you see that it's truly universal. You have 166, only 5 countries that acceded to the convention in 2020. On Iraq, you will see on the website, there is one decision, despite the fact that Iraq is not a party to the convention, and there's a trend. They do want to become party. This is at least my feeling, and hopefully they will start applying, even by not being party, the New York Convention, and you have that decision of 30 September 2012, and that reflects, hopefully, that Iraq will become a party, as many have already. On the civil law, common law, I want to say one word on that. you have really the way that the first 15 jurisdictions were selected, and also in the way that we have expanded to 45 and then now to over 70, is really to make sure that the most reflective jurisdictions that are doing arbitration and that have a case law in relation to the convention are represented. And this is both civil and common law jurisdictions. On common law, I mean, the first 15 jurisdictions included the US, the UK, Australia, India, for example, and Hong Kong. These are extremely important jurisdictions, and you will remember that the case law in the UK, in the US, and India do cite the UNCITRAL's guide. So these, I mean, it's really universal, and that is also reflected in the website and in the UNCITRAL guide. On more specific on Korea, I wanted to say that one thing that I didn't mention is that yes, there's lots of decisions. We do hope we have more and more. And again, we have our contributors who we're thankful to for that. And the decisions that are put on the website and that are referred to in the guide are those really that are on the application and interpretation of the convention. So if a decision does not necessarily refer to it, it may not be included. But that doesn't mean that that jurisdiction is not pro-arbitration or that it doesn't have a pro-arbitration case law. And I will take the example of France. If you look at the French case law, it's not as significant as the US case law, for example, because the US case law will refer to the convention almost systematically, but France is adopting Article 7, which is essentially allowing for a even more pro-arbitration bias than the convention itself, and therefore a number of decisions in France will not necessarily refer to the New York Convention, whereas France has a very pro-arbitration bias, including on enforcement and application of the New York Convention. So I wanted to just say that. On the challenge, that's my last point. And I agree with Jonggi, this is a powerfully successful instrument. It's almost universal. One thing that the guide does show is that there is no, I mean, any concerns about the convention are unfounded, because you see that the way that jurisdictions around the world are applying and interpreting the convention is overwhelmingly consistent. So there's no concern, and again, this is from common law and civil law backgrounds. There's no need indeed to revise. There's no hope to arrive today at the same universal agreement between 166 states, especially, and Junge referred to investment state arbitration. In that type of arbitration, states are defendant and develop a sort of defendant mindset and resistance of enforcement. So if we were to revise the convention today, it's not said that we could achieve the same liberalism that we achieved in 1958. And one point on the blockchain, since we discussed that, and on the on ISDS, I think that the way that the convention has been framed and structured is that it's forward-looking. And when you look at the convention, it has adapted, and again, that is a reason why you have this overwhelming, consistent interpretation application around the world, is that it is adapting to the evolution of the law. And in relation to blockchain and electronic communications, I refer everyone to the 2006 recommendation of UNCITRAL on Article 2, which essentially says that you have to look at the circumstances not being exhaustive, and that is an indication, of course, to the courts when they apply the New York Convention. So my last conclusion is that the convention is 62 years old, but it's alive and kicking. Thank you very much.
Thank you very much, Yas, for confirming that the convention remains vibrant and alive. Very good for us to hear. Now, Natalie, we have a few minutes left for you to perhaps elaborate a bit on Kyung-jun's comments. So you have the floor now, Natalie.
Thank you very much, Athita, and thank you very much for the very, very thoughtful questions. First of all, dealing with the issue of government-led quasi-judicial mediation committees, I think it's really good to hear that there is this good institutional support for mediation in the Republic of Korea. And At the same time, I do think that the Singapore Convention still remains useful against that backdrop. As what I understand, and I'm no expert, I've only just started reading about these committees, is that they need to be statutorily established. And they could be specific to certain content areas, such as copyright, consumer disputes, and so on. Whereas the Singapore Convention on Mediation would apply generally across the board. And in this sense, it would be a helpful means by which the space can be filled in the meantime before any of these committees may be established that allow the settlement agreements to be received differently in the context of those committees. Very quickly onto this idea of online mediation. I think there are many strengths to online mediation for appropriate disputes, and we've seen how COVID-19 has expedited the move towards online mediation simply because of the restrictions on physical travel. With online mediation, there's a removal of this need to be physically present in the same space. It also allows for a distancing between the parties that could be helpful and more facilitative of more reflective thought and reactions to what is happening in the mediation. But at the same time, there are also certain drawbacks, and I'm only being illustrative on both the strengths and the drawbacks, and that is that you lose out on certain physical cues like body language, which can be very informative in the mediation setting. That being said, I do think that the Singapore Convention's practical approach to the in-writing and signature requirements means that it is helpful not just for electronically prepared mediation agreements, but also for the online mediation context, because when you're not physically in the same space, you're still able to exchange your documents, sign them, and prepare them, and they will still be recognized in the under the framework that is established by the Singapore Convention. And so just some very brief remarks in the interest of time. Thank you.
Thank you very much, Natalie. I think with that, we can conclude our panel. Although the time seems to have seems like we're over time, we actually stayed within our 1 hour time frame, I think, being the first panel to do so. So I thank you all for that. Yaz, Natalie, Jungi, Kyungjun, thank you, and thank you all for your attention. With that, I end this panel. Thank you.
I appreciate all participants of session 5 for your thought-provoking overview on our topic. This brings us to the end of the session 5. We'll now recess for a 10-minute coffee break and reconvene at 4:50 p.m. We would like to ask for your kind understanding for not giving you enough time for a break for the sake of time. Please help yourselves with the refreshments laid out at the lobby, and you may bring those snacks to your seat. Thank you. 예, 안내 말씀드리겠습니다. 10분간 휴식하고 4시 50분에 다음 세션을 시작하도록 하겠습니다. 회의장 밖에 로비에 차려져 있는 음식들을 즐겨주시면 되겠습니다. 그리고 자리에 가져와서 음식을 즐기셔도 됩니다. 예, 감사합니다.
하나 둘 하나 둘 하나 둘 하나 둘 하나 둘 하나 둘 셋 하나 둘 셋 테스트합니다. 테스트합니다. 하나 둘 하나 둘 하나 둘 마이크 테스트합니다. 마이크 테스트합니다.
Distinguished guests, the final plenary session will commence in a moment. Please enter the conference room and take your seats. Moderator and panelists of the final session, please come up to the stage and be seated in your designated seats. Thank you. 외교빈 여러분, 금일 회의.
Ladies and gentlemen, the final session of the two-day international conference is about to begin. The final plenary session is about to begin, so those of you outside, please come inside and take your seats. And also, I'd like to kindly invite the chair and the panelists for this final plenary session to join us up on the stage. Thank you.
Ladies and gentlemen, may I have your attention once again? The final session of this conference will begin shortly, so please enter the conference room and take your seats. Moderator and panelists of the final session, please come up to the stage and be seated in your designated seats. Thank you. Now it's time to proceed to the final plenary session. It is a great pleasure to introduce our last moderator of the conference, Mr. Il-won Kang, the former Justice of the Constitutional Court of Korea, will preside over this session. Mr. Kang holds his LLB from Seoul National University and LLM from the University of Michigan. He was appointed as a judge of the Seoul District Court in 1985 and served as a judge for 27 years. He had been a justice of the Constitutional Court from 2012 to 2018, and he served as a member of the Venice Commission and worked as a bureau member of the Venice Commission during 2013 to 2019. Now, I would like to turn the session over to Mr. Kang.
Thank you for your kind introduction. Now we've reached the final session of this conference. As a chair of the final session, I would like to say this one first. Thank you very much for this wonderful venue and meaningful conference. Thanks for the president of the Judicial Policy Institute and also all members of the host organizations and sponsors. I think it is wonderful to have a chance to meet with this in person also, not only in person, but also by this internet. It is kind of the fruit of the digital revolution of this year. And because we are just behind the schedule, I make my introduction very short. In this conference, we've been discussed about international commercial litigation and recent development and future challenges. And we heard a lot of new developments all around the world. So this time, as a wrap-up of this conference, I would like to give all the panelists have a chance to share their knowledge and wisdom with the audiences, not only in this venue, but also who watch this conference via internet. So I don't think it is a good idea to give specific questions to all the panelists because they have their own expertise. So I let them speak what they want as a kind of a conclusion of this whole conference. I personally prefer the free dialogue between panelists, but I think it is not possible to give floor from here to the Zoom. So this time I give a floor just in turn. And as the first panelist, I want to introduce Honorable Justice Quentin Law. We met him just a few hours ago. So I just give this mic and floor to Honorable Justice Quentin Law. Justice, are you there?
Yes, I am. Can you hear me?
Sure.
Yes. Thank you very much. Thank you. Good afternoon again, everybody. I'm just going to make about 6 or 7 short points so that we will keep within time. The first thing I want to say is that yesterday, the Federal Reserve Chairman, speaking at the European Central Bank's Forum on Central Banking, made 3 points. 1, the economy as we knew is probably a thing of the past. 2, we are recovering to a different economy. In other words, it won't be the same. 3, the pandemic has accelerated existing trends in the economy and society, including the increasing use of technology, telework, and automation. Those are the 3 points he made, and I would like to say, I think this pandemic will also accelerate the changes in the way the courts will operate in the future. The second point I want to make is this. Given today's trade, commerce, and manufacturing world, there are already multiple related contracts. They are the order of the day. So commercial courts dealing with such international and related commercial contracts need to have a deeper understanding of other courts and other legal systems. We cannot each operate within our own silo anymore. This kind of shared knowledge will help courts consistently decide issues like, for example, jurisdiction, forum convenience, and available remedies. Because every time we have differences, it's a huge cost to businesses. And there should be a concerted effort to try and get a lex mercatoria going. And it is therefore important for commercial courts to reach out to each other. Let me just give you a very real and simple explanation of what will happen as we go forward, as the pandemic wrecks economies, businesses, and business relationships. What will happen is I think the world will see more insolvencies. Insolvencies work territorially. Is this good? Of course not. I quote, for example, the Hanjin shipping insolvency. Singapore had the occasion to try and make sure the orders we make on any subsidiaries and disputes were consistent with what was happening in Korea, where the head office was situated. I did the same thing in a dispute where a company in Malaysia was undergoing restructuring. I gave judgment, but I ordered a stay pending the outcome of the restructuring in Malaysia. This is what commercial courts should be doing. And I'm happy to say Singapore and the Korean Bankruptcy Court have already established warm ties and cooperation. So what is a net result of this? You will find that in May 2017, as many as courts from 29 countries met in London to form the Singapore International Forum of Commercial Courts. And it recognized these differences across legal systems, and it set up 4 initiatives. One was to produce a multilateral memorandum of guidance to explain how judgments, money judgments in one commercial court can be efficiently enforced in another. And I'm happy to say there's now a multilateral memorandum of guidance that has been signed by some 30 countries. It's now in force. Next, there is a working party to establish the best practices with a view to making litigation more efficient. I'm hopeful that this will produce something next year that all commercial courts can look forward to adopting. And commercial judges should spend time in each other's commercial courts to learn about the practices in each other's jurisdictions. So we see now there's a move amongst the international courts to get together and to work towards commonality, to work towards harmonization. It may be a long time before we get there, but we need to make a start. Now, in the International Commercial Court in Singapore, we will be introducing new rules next year. And this is just an example of how an international group of judges got together and we have set out a new flexible civil procedure to be adopted. You can go by the traditional writ action. You can go by the traditional originating summons, where there's not much dispute on fact and perhaps it's just construction of documents, or we can even adopt memorial systems. And what is the aim of this flexibility? It is so that if we have an international lawyer who steps into any of our courts, he should not find things so alien or unknown to him. It will be the same for any lawyer acting in an arbitration. These are procedures he will be familiar with. And we have also enacted legislation that allows us to disapply some of our own rules that a civil lawyer might find strange. So, where are we moving towards? We now want to find, and we hope to establish, links between the different courts. We should work towards harmonization of laws to develop a lex mercatoria, which is something that many courts can adopt just in relation to international contracts. And I think this is something that we should all aim to move towards. Now, I don't want to take up a lot of time, but I think you will find that with the economy recovering, we hope so by next year, there will be more opportunities for us to interact with each other. And so let me end by saying this. International commercial disputes are no longer limited to one or two resolution methodologies. It used to be the favorite that we use arbitration, international arbitration. That's no longer the case. You can proceed now to international arbitration. You can proceed to domestic litigation. You can go to an international commercial court. You can go into mediation, or you can do ADR. So complex litigation can be broken up. Some can go to ADR, some can go to expert neutral evaluation, and some perhaps can go off to the courts or international arbitral tribunals to decide questions of fact and law. So I say today to businessmen who unfortunately find themselves with a dispute on their hands, they are fortunate. They will have a whole suite of options to deploy to try and resolve their problems. And on this hopeful note, I will end. Thank you.
Thank you, Mr. Justice. Yes, as he said, the Singapore court is quite leaders in Asia in terms of civil procedure, not only civil procedure, but also in ADR. So it is quite a good kinds of conclusion from the Singaporean aspect. Now I'll give to the mic to the Christopher Bernasconi, the Secretary General of HCCH. We have met him yesterday. Mr. Bernasconi, are you there? Yes. Nice to meet you again.
Thank you very much, Mr. Chair. I hope you can hear me.
Yes, you are very clear. Please.
Wonderful. Thank you. Well, hello from sunny The Hague today. Hello to all of you, distinguished chair and co-panelists, dear participants in the room and online. At the outset, let me thank the organizers, and in particular, of course, the Judicial Policy Research Institute, all the speakers and panelists for their insightful contributions over these last 2 days. Unfortunately, I have not been able to follow all of the sessions, but from what I have seen and heard from colleagues, the discussions were very fruitful indeed. The prevailing theme of the conference, of course, has been the international commercial litigation. And as we have been reminded over the course of these sessions, is that cross-border transactions, cross-border interactions, cross-border relationships are increasing, at least generally speaking. The current pandemic has obviously put some hold on that, but I think as we will come out of this pandemic, there will be a need for more cross-border cooperation, for even more and there will be more cross-border interaction also, as Justice Lowe just alluded to. So cross-border relations and transactions are becoming more and more common, no doubt about that. And as a result, as I like to say, we are living in a world of private international law, a world in which all we do, the relationships we enter into, the commercial transactions we conclude, all very quickly have this cross-border element and thus do raise questions of private international law. And there is, of course, also a time for harmonization of substantive law, which is becoming more and more relevant too. While cross-border litigation is inherently complex, we also have seen the wide variety of instruments at our disposal and the disposal of those operating across borders. These instruments are designed to provide legal certainty and predictability, provide effective cooperation mechanisms across borders to facilitate trade and commerce, providing effective access to justice in cross-border cases. Now, from our perspective, the HCCH perspective, I'm very pleased that we have been able to contribute to these discussions, showing the relevance of our conventions and instruments, of course, along with the many other discussed during the conference. But let me just highlight in particular again the importance in the overall context of the conference's theme of the 2005 Choice of Court Convention and the 2019 Judgments Conventions, their relevance for international litigation. The 2005 Choice of Court Convention is, dare I say, quite straightforward. It provides this legal certainty and predictability that is so essential to cross-border commercial operators. It is, frankly speaking, relatively easy to implement. So it comes with high benefits. The 2019 Judgments Convention, okay, is a newer convention, and we still have to, complete its assessment. But when you look at it, it's actually not a terribly complex convention either. It too provides legal certainty and predictability. It too provides this effective access to justice that is so important. And yet, when I look at our statistics, I am always struck by just how long it takes for these internationally negotiated instruments to enter into force. On average, it takes about 6 years for our core conventions to enter into force. Now, this may have to do also with the system of our conventions. We don't have signatory conferences or events like that. But 6 years is a long time. It even takes, of course, longer for these conventions to take up and reach reasonable levels of number of contracting parties. It takes 13 years for our core conventions to reach the level of 20 contracting parties. Now, I really hope that the Judgments Convention will enter into force much sooner than the average. And as I was saying yesterday, the early signs are actually very promising and encouraging. And we also hope that the Choice of Court Convention will reach the level of 50 contracting parties much sooner than what has been the case for other core conventions in the past. And I'm saying this against the background, again, that these conventions have been negotiated and have been developed, adopted on the basis of consensus and have well been received by the international community. So I really wish to extend an invitation to all in the room, to all on the call, all the government authorities around the world that are listening to us, to study these instruments and to consider, actively consider joining these two important conventions and of course the other conventions as well. What's the point of developing these international instruments that respond to a real practical need if it takes so much time afterwards for them to be implemented? Of course, at the HCCH, we are not stopping here. We have legislative work in the pipeline, including work on direct jurisdiction, a possible instrument on direct grounds of jurisdiction as the logical corollary of the Choice of Court Convention and the Judgments Convention. And in response to the comment just made by Justice Lowe, also I'm pleased to inform him that one of the things we are exploring in this context is how best to overcome the issue of parallel proceedings in different jurisdictions and the possible use of forum non-convenience in this regard, including in relation to civil law jurisdictions. Including also by exploring ways of cooperation between courts, between judges to overcome these challenges of parallel proceedings. So I think these are interesting and hopefully promising developments. Let me also quickly say that I have always been heartened to see the continuing engagement of the Republic of Korea and its many experts in our work. Korea has always followed up when it has promised action. I have seen that personally in relation to the Apostille Convention, Service of Process Convention, taking of evidence, and also the Child Abduction Convention. So we look forward to working with the Korean authorities and in particular exchange more often regarding the use of technology in courts and litigation, whether more traditional technology or more recent developments such as artificial intelligence or DLT and their use in cross-border proceedings. Looking forward, we at the HCCH will be focusing more and more also on the strategic development of the organization, building capacity globally and seeking true universality and inclusiveness. We have been delighted to welcome our 86th member of the HCCH just last month. And we know that a few more are in the pipeline, including, for example, Thailand. More than 150 states are, as we speak, connected to our work one way or another. And states like Indonesia also show very tangible, real interest for our work. The point here, however, is that our secretariat cannot handle all of this alone, and so we need the help and the involvement of our members to really lift the organization to the next level. That's really from our side what we wanted to contribute from The Hague. I know that my colleague, Professor Yung Chao, our new representative of our regional office in Hong Kong, will build on these remarks from a regional perspective. Thank you, Mr. Chair.
Thank you, Mr. Secretary General. Actually, Korea is the 9th largest player in the international trade market. So HCCH is very important to Korea. Also, Korean judges, like me, as a former judge and former justice, we are a fan of the HCCH. So thank you for your contribution. Now I'll give this floor to Mr. Yoon Chao. He is a representative of a regional office for Asia and the Pacific of the HCCH. Also, he is a professor of the University of Hong Kong. Mr. Chao, yes, you are there. Please, floor is yours.
Thank you very much, Chair. Good afternoon, everyone. I would first of all congratulate the organizers for this very successful event on the important topic of international commercial litigation. In this globalized world, many legal issues go beyond national border and require international attention. I'm very pleased that the organizer, the Judicial Policy Research Institute, was able to co-host the event with the 3 international organizations in the field of harmonization of international law rules. As the chair has mentioned, and also as Christopher has mentioned, I'm representative of the Regional Office for Asia and the Pacific of the Hague Conference on Private International Law. The regional office represents the HCCH in this region. It was opened in 2012 with a mission to act as a bridge to enhance communications and understanding between the Permanent Bureau of the HCCH in The Hague and states in the Asia-Pacific region. The Republic of Korea is a major player in the field, and I very much look forward to working very closely with Korean authorities in the near future. Now, in the last 2 days, there were very heated discussions and very excellent presentations. So I have the following 3 points to share with you. First, the 3 international organizations, namely UNCITRAL, UNIDROIT, and the HCCH. Actually, these 3 organizations are not working separately. There are various areas that they can work together and cooperate. One typical field is international commercial contracts. Apart from the successful UNCITRAL CISG and the UNIDROIT PICC on the substantive legal rules, there is a need for conflict of law rules to govern international commercial contracts. The HCCH principles were thus in place to emphasize the importance of party autonomy principle. I believe this is one very successful area, an example for the cooperation, and we can witness the complementary roles among these 3 organizations. Secondly, technology is becoming increasingly a very important factor in conducting international commercial litigation and dispute resolution. This is even so in view of the ongoing COVID-19 pandemic. Technology can be used to facilitate various aspects of dispute resolution process and bring convenience to the community. E-service is no doubt an important way to facilitate and simplify the whole process. We also noted the use of technology in court litigation. So apart from many measures that have been taken by the HCCH, including the I-Support project, etc., I'm very pleased also to mention the ongoing efforts of the HCCH in deliberating the use of online dispute resolution to protect the interests of international tourists. So we are looking to online negotiation, mediation, and arbitration, and of course, following the successful example of the UNCITRAL technical notes on ODR in 2016. Thirdly, in the field of recognition and enforcement of final decisions from dispute resolution process, we are very happy to see the 3 pillars are already in place. The New York Convention, the Singapore Convention, and of course, the 2019 Hague Judgment Convention, which provide important impetus for international commercial litigation. And as our Secretary General has mentioned, we look forward to see that the Judgment Convention will enter into force in the near future. Enforcement and recognition has always been a very difficult issue. So now with these 3 pillars in place, mediation, arbitration, and litigation are put on the par. And we will see that they will contribute to the realization of access to justice. This will be most important to the protection of the rights and the interests of the disputing parties. Accordingly, I think the Conference on International Commercial Litigation is the most meaningful at this critical stage. I'm very pleased that fruitful discussions have taken place in these 2 days. I thank the Judicial Policy Research Institute for organizing such a forward-looking event. As a regional representative of the HCCH, I hope to build networks within our region, develop deeper understandings of the Hague Conventions, and facilitate good practice and consistent implementation of these conventions. We have been working very hard and working very closely in the past years in organizing various events to promote the Hague Conventions. I very much look forward to our continued efforts in furthering collaborations. As the regional representative, I will always be at your service. So with this, I conclude my sharing. Thank you very much.
Thank you very much, Professor Chow. Yes, please. I strongly agree with the 3 points of the Professor Chow, and especially I want to add something more, that the procedural right is not just the right of the code. I think the procedural right is one of the fundamental rights and one of the human rights of all humankind. Yes. And now we move to the UNIDROIT. Let me introduce the next panelist, Mr. Secretary General of UNIDROIT, Ignacio Tirado. We met him yesterday. Mr. Secretary General? Yes, floor is yours, please.
Thank you very much. Please, if there is any sound issue, let me know. Thank you very much. It's a pleasure again to greet you from also here, a sunny room in early autumn. Allow me to start these final remarks by highlighting and supporting everything that my fellow colleagues and friends from the Hague Conference have just recently stated. As you all know, we do international private law rather than private international law, and therefore our work is absolutely and fully complementary with the work of the Hague Conference, which is absolutely extraordinary, as all of you know very well there in Korea. I'd like also to support the call of Secretary General Bernasconi for the ratification of the Judgments Convention, which we also deem a very important instrument, which can be a game changer in judicial cooperation internationally. My final words would be in the shape of a few reflections rather than a specific analysis of concrete items. I think I'd like to share with you some thoughts, and perhaps that would be something that you can go home with and ponder on. So it's just food for thought. I would have loved to be there for an exchange, but that is unfortunately in these times not possible. My first reflection concerns judicial activity and transnational law instruments. Of course, all our work is only important to the extent that you, judges, apply it, and to the extent that the judicial activity considers our work and brings it to reality by implementing it. So we are in your hands in a way, and this is where I would like to share a couple of reflections. On the one hand, how can the soft law instruments of our transnational organization like ours, how can they help in the judicial making of resolutions of decisions? Soft law instruments, because of the way they are approved and drafted by our three organizations, and I at least speak for my own, although I know we share the same quality standards, are best international practice. They are considered a standard, and therefore they are already not only of the highest quality, but also include a very strong balance of the different legal families, and they take into consideration the different realities in the world. So they are ready to be applied and used as an interpretative tool by the different countries. That's the idea. So, for example, in the case of the uniform of the UNIDROIT principles for international commercial contracts, as I mentioned yesterday, the principles already influenced the amendment of the legislation of France, of China, of Russia, of Argentina, of a number of countries. Well, their interpretation of judges in the application of the rules that have originated in transnational law instruments might want to take into consideration the finality and all the background work that was done in the transnational organizations, which led to the domestic law reform. In other words, best practices done at the highest international level can help and inform the decision-making process of the judiciary at the domestic level. Second, and perhaps very, very important, most important, is how applicable law, such as treaties and conventions, hosted and drafted by transnational law organizations, are to be interpreted domestically. This is an absolutely key issue. And it is of the utmost importance that the judiciary remembers that when they are applying a treaty, they have to consider their international origin and the fact that a treaty implies some sort of committee between all the countries that apply the system. So when it comes to applying a treaty, which is, for example, seeking to enhance access to credit or seeking to ensure that adequate protection to creditors in access to credit, if there is the idea of trying to modify the rules to adjust to what might be general local customs, the problem of doing that is that they would be contradicting the general contract of those who signed the international instrument, and therefore they would be undermining the legal certainty of the treaty. In other words, in a way would be undermining, by misapplying locally the treaty, the judiciary of other nations. So it is important to bear in mind the finality of the treaty and the international law origin of the treaty when it is being applied locally. Therefore, flexibility is less the case as it would be if you're applying a domestic law. This is something we have seen very clearly in the application of the Cape Town Convention. As we said yesterday, the aircraft protocol concerns airlines. Airlines are now under a threat. Many of them are filing for insolvency proceedings, and the strength of the treaty lies precisely with the fact that the judiciary are doing an extraordinary job at applying the treaty strictly within the limits of the international instrument, and they are not giving in to the temptation to misapply in order to provide for a parochial interest, which is ultimately not so. Another reflection I'd like to share with you concerns a new, the moment or the item in the entire chain of application of the law, which is weakest in reality, although we might not realize. Many countries, also in the Asian region, have very good laws, but the problem comes when it comes to implementation. And the part of implementation of the laws, which is weakest tendentially in most countries, is enforcement. Enforcement is an especially important and weak and sensitive area where the work of transnational organizations is key. And it is key when it comes to providing streamlined, when it comes to providing best practices, because of course enforcement touches upon the backbone of public interest in a society, and therefore what can be done at an international level, apart from coordination rules, as was mentioned before, is come up with best practices so that countries can apply those best practices to their own systems. That's what we are doing currently in UNIDROIT, collaborating with our partners. with the World Bank as well, and with other organizations which are very much concerned with the implementation of the rule of law. I'd like to just call your attention or draw your attention to the need to improve enforcement systems and to follow our work on enforcement. Has been going on for a little while, but it's gaining strength and speed these days. Technology is going to be key. Technology entering enforcement is going to avoid many of the problems that currently exist, either by the judicial system or more often by those who outside the judicial system, such as bailiffs and other auxiliary bodies that need to take into reality what the judges have decided. And this will allow me, the introduction of technology will allow me to finalize, but let me, before that, just bring to your attention one thing which I wanted to mention yesterday and I forgot, which is my colleague and friend, Professor Anna Veneziano, my deputy who will speak after me, explained to all of you already about the UNIDRA European Law Institute principles on procedural law. As she mentioned already, we have the UNIDRA principles with the European Law Institute. We have the UNIDRA principles on procedural law, transnational procedural law, with the American Law Institute. And we are in the process of starting another document to do the same with Latin American partners, so that there is a UNIDRA Latin American Law Institute or its equivalent, possibly the body within the Organization of American States, to draft the similar principles. We believe, and we've already heard interest, but we believe it would be extremely important that also UNIDRA partners up with an Asian legal organization or a number of them to try to come up also with a set of principles which apply to Asian transnational procedural law. That would close the loop and allow us to cover the entire world. So I would like to encourage, of course, the Judicial Institute, but not only anyone who's looking at this video and this conference from the Asian region to perhaps show interest, contact us, and set in motion this alternative. Final reflection, also, as I said, regards technology. Technology is the big challenge because it implies a change of paradigm for the judiciary. It is, in a way, a de-judicialization, because what it does is it creates an automatization of decisions. Sorry for all these difficult long words. It creates too many automatic remedies for the parties. And those automatic remedies, all covered in the package of technology, seem to leave little space for the judiciary to actually do something about it when the interest of the parties can be affected. Our project on digital assets and proprietary rights concerning digital assets, in part together with Ancestral, is, we believe, of extreme importance on these. And what we're trying to do is we're trying to unpack and analyze conceptually with some of the most brilliant minds from the most brilliant universities in the world as to what that technology legally is. And once we know what the technology legally is, we're going to offer an instrument which is going to be extremely useful to the judiciary, because the work will be done for you in the sense of explaining and fleshing out what areas which seem technology and engineering are actually spelled out and described in legal terms. So allow me just to finish thanking you all very much, and also saying that we have very intense collaboration with the Asian region. We have extraordinary experts and collaborators from Japan and Tokyo, from China, of course, and from Hong Kong, which is and its extraordinary legal hub. We do a lot of work also with Indonesia and with other countries, as well with Korea. But it would be our desire, most firm wish, to strengthen our collaboration with Korea, with Korean experts, with the Korean judiciary, and with the Korean government moving forward, so that we can translate that reality, which is Korea as one of the main exporters in the world, one of the main players in international commerce, to also work with us in a more intensified manner. Thank you very much. Congratulations for an extraordinary job, and I look forward to seeing you all in person.
Thank you, Professor Tirado. Yes, I strongly agree with his idea of kinds of organizing the Asian Law Institute. As far as the law and rights is concerned, Asia is quite a little bit behind the global standard. So in this sense, we Asians, Korean, China, and Japanese, and all Asians tried to cooperate to make some kinds of cooperation in fields of not only in economic fields, but also in legal fields. Yes. And now I will give the floor to the Deputy Secretary General of UNIDROIT. We met her yesterday or so, Ms. Professor Anna Veneziano. Yes, you are there. Do you hear me?
Yes, I can hear you very well. Thank you very much, Chair, and good afternoon or good morning, not only to our distinguished Chair, but also to all panelists and audience. And allow me very quickly to thank once again and congratulate the Judicial Institute for the initiative of this conference. Again, we could not participate in the whole of it, but what I heard was very interesting. And the discussions of the relevant instruments and projects of all three sister organizations together active in international lawmaking in the areas that we addressed was particularly important. I think this conference is a testimony of the proactivity of your organization, which I would like to commend, of the relevant role of the judiciary, and of the importance of creating channels of discussion and communication with and within the judiciary, which was underlined already by many participants also in this last panel. All the uniform law instruments discussed rely on the role of the judiciary for their correct implementation. And secondly, allow me to say that I was impressed by the presentations of the panelists during the discussions yesterday, and we will take back to UNIDROIT your valuable comments and suggestions. Now, allow me to make one point on the merits of the issues that we discussed. I would like to once again emphasize a point related to contract law and the role of a soft law codification such as the UNIDROIT principles, which I think came out quite clearly from our discussions. The UNIDROIT principles are a versatile and flexible tool, and as such they can be helpful in a variety of ways and situations. And because of their flexibility, for example, the provisions on hardship that I mentioned also yesterday, and more generally, the express attention to the issues of long-term contracts, it is not a surprise that they have been repeatedly referred to and mentioned in the most recent discussions on solutions to contractual disruptions as a consequence of the pandemic, but also solutions for a post-pandemic legal environment. They are important certainly in arbitration, that was underlined. They are important for parties, but I would like to underline their possible usefulness for mediators and for domestic court judges, both in the case parties have expressly referred to it, and I was happy to hear the Koreans' law modern approach in this respect, and as it happened in many instances around the world, as support for the interpretation of domestic law when that interpretation is evolving or changing. And finally, I would like to make an additional point that I did not address. Another possible way to disseminate the knowledge of the principles and to render them especially useful in practice. Going back to what was discussed yesterday, in particular by Professor Chong, which is to target a specific market sector and develop a specific project in that area dealing with different types of commercial contracts. And here we have indeed a project on principles of reinsurance contracts, which are a particularly relevant tool from an economic perspective. They are global and they are important in these emergency times. A first part of this project was published in 2019. They are the result of an academic initiative with participation of practitioners from the insurance and reinsurance world. And at the beginning of the project, the leaders expressed the view that the proposed principles presuppose the existence of adequate rules of general contract law, and they, rather than attempting to recreate those rules, the proposed principles had to be drafted in such a way as to ensure consistency between them and the UNIDROIT principles as these general adequate rules of commercial contracts. And as a result, UNIDROIT was invited to participate. So we think that this is one important way forward in looking at transnational, international contracts. And to summarize in the interest of time, I would like to go back to the point already made by many panelists and participants that the strength of the soft law and of the principles is that they are a flexible tool. They can be used in different ways depending on the context, and judges do play an important role. So we really hope to have even more participation and input and interest from your country and from the whole region. I hope I have not spoken too much. I know that there is a sensitivity about time, and so I would like to give back the floor to our distinguished chair. Thank you very much.
Thank you, Professor, for your wonderful contribution. You are just on time. Thanks for you. We are on time now. And now, the remaining 4 panelists are with us in this room. So now we can speak more conventional ways. So now I'll give it to my mic to Mr. Lee. Jae-sung Lee is a legal officer at the International Trade Law Division of the UNCITRAL. He currently functions as a secretary of the working group on 3 and 4? Working group 3, yeah. 12. 12, I'm sorry. And now I'll give it mic to Mr. Lee, please.
Thank you, Chair. Good afternoon, almost evening here in Seoul. Good morning to Christophe, Anna, and Ignacio in the sunny Rome and The Hague. It's good to be back in Seoul, my hometown, and to meet old friends and Korean delegates who participated in our working groups, the UNCITRAL working groups, including the chair, who actually participated in one of our working groups. Now, nonetheless, I'm very gloomy because it's now almost time to go home for now, because I'll be taking the plane to Vienna tomorrow night and leaving my friends and family behind, and I'm not sure when I'll be back. I really hope that the travel restrictions can be soon lifted so that all of us can meet in person again. I say so because while it is a great pleasure that UNCITRAL and the 2 sister organizations, the Hague Conference and UNIDROIT, has gotten together, teamed up with JPRI to co-host this international conference, I, along with Atita and Eun-young from the Regional Center from Asia, the UNCITRAL Regional Center for Asia and the Pacific, are the only 3 representatives of the 3 organizations present in this room. As such, I mean, we look forward to another opportunity quite soon where we can all meet and discuss all the topics that we discussed over the past 2 days. And I can only reiterate the importance of coordinations with the 3 organizations and with other international organizations and local organizations like JPRI. Now, during the past 2 days, I think the discussions have focused mainly on areas where the three organizations have produced international legal instruments. My short comments this afternoon will look into the future rather than what has already been achieved. What can we or you expect from UNCITRAL as it pursues the mandate of harmonizing and modernizing international trade law by preparing international legal norms? Now, first, while a number of speakers have mentioned the impact of COVID-19 on a number of international instruments and their application, I think the ways and means to negotiate and formulate international standards will likely change due to the COVID-19 pandemic. Now, as Christoph has noted, we have to reach consensus on a number of different international legal instruments, and the way to actually achieve consensus has to be also looked at. Now, the Working Group 2 session that I serviced this February in New York in person was the last of its kind, and all the working groups, including the Commission session of the UNCITRAL, has been transformed into a hybrid format. And it is likely that this will continue until the first half of 2021. Now, we have issues. We have interpretation issues. We have time issues. And we have to overcome these issues and problems in order to reach consensus. And this is something that the three organizations will have to overcome. Of course, this does not mean that the rulemaking by the three organizations will stall. It will actually continue. I've taken part in the Hague Conference ODR project for tourists and visitors, and also the UNIDRAW model law on factoring projects where I participated remotely. And at UNCITRAL, we're also planning to make use of other technologies all possible means to make sure that the rulemaking would continue. Of course, we'll not be having coffee breaks like we had today, but still, even in a remote environment, we're trying to find ways that the rulemaking would continue. Now, one of the areas that we discussed yesterday was secure transactions, and as to the future legislative work in that area, I'm happy to report to all of you that work will continue on as Working Group 1 of UNCITRAL, which is currently focused on micro, small, and medium-sized enterprises, continues to address the entire life cycle of MSMEs. They've started with the establishment, a simplified business format, as well as the unfortunate insolvency of the MSMEs. And in that context, we'll be looking at enhancing access to credit for MSMEs in the future. This will not only include secure financing using movable assets, but will be broader so that we can address a number of different financing techniques for MSMEs. And as Ignacio mentioned yesterday, we are happy to collaborate with UNIDRAW on the continued preparations of the model law on factoring, as well as a model law on warehouse receipts. Now, since we're looking into the future of dispute settlement, let me just brief you on what is currently planned and what will happen in UNCITRAL in the near future. I currently function as the Secretary of Working Group 2 on dispute settlement, which is currently preparing expedited arbitration provisions, rules that will accompany the UNCITRAL arbitration rules, mostly likely as an appendix. The aim is to simplify and streamline the arbitration process, and this work started to respond to the calls for more efficient procedures to save cost and time. So the new rules, which would apply when the parties have explicitly consented to its applications, would have a sole arbitrator as the default rule, a simplified procedure for appointment and designation, some additional requirements for the notice of arbitration, some emphasis on the consultations that would be required, the possibility to not hold hearings, a time frame for 6 to 6 months for rendering of the award. Now, even before COVID-19, there was discussions in the working group about whether the use of technology in expedited arbitration or arbitration generally, mainly for holding case management conferences, for hearings, and for taking evidence, including witness statements, should be highlighted in the expedited arbitration context. Now, as we know, the COVID-19 pandemic has accelerated relevant practice in that field, and in September, the working group agreed that the expedited arbitration provisions should include a general rule that would address the possibility of the arbitral tribunal to utilize different means of communications during the proceedings and to make use of virtual and remote hearings. Now, as Dr. Jung Hwan mentioned in his presentation on electronic litigations, this is the recent trend in dispute settlement. Now, why did the working group decide to include an explicit rule in the expedited arbitration provisions? The main rationale was that such a rule would not only recommend, but also empower the tribunals with express discretion to make use of technology and to hold remote hearings. Now, this is because whereas the use of technology generally addresses the aim of having an efficient resolution of the dispute, there may be concerns about due process and fairness that arises from the use of technology. And I think as judges are here in the room, you will be getting those questions in your cases, because some would be saying that they were not given the reasonable opportunity to present their case. Now, let me just conclude by saying that UNCITRAL is continuing to work on a number of different fields in dispute settlement, including in ISDS reform. Working Group 3 is continuing its work to develop reforms to ISDS and is entering into its third phase of its work, developing different reform options, including a code of conduct, some issues relating to the appointment and selection of adjudicators, to address frivolous claims, as well as multiple proceedings. Now, following the adoption of the Singapore Convention on Mediation and the corresponding model law on mediation, we are also preparing a revised mediation rules, which would also come into force next year, as well as the notes on mediations, which will also be similar to what we have for the notes on arbitral proceedings. So all of these texts will be presented to the Commission next year during July, so that's what will be presented as new texts that will be coming from UNCITRAL. Now, in addition, there is some additional exploratory work that is being undertaken by the Secretariat. First is the dispute settlement as part of its work in the digital economy, particularly for disputes that arise in the e-commerce field. There's also work being undertaken on dispute resolutions with regard to high-tech industries, which is also something that the Secretariat is working on, as well as we're following developments in online dispute resolutions. As Yoon Jao mentioned, we do have the 2016 technical notes on ODR proceedings, but there has been a number of developments, including within the APEC. And so we're looking at platforms and the use of other technologies to facilitate dispute resolutions, and it might actually end up in a revision to the ODR technical notes. Furthermore, upon the proposal from Japan, the Commission requested the Secretariat to compile and collect information about developments in dispute settlement, including those in response to COVID-19, and a project proposal will be submitted to the Commission next year for its consideration. So that was kind of a very short wrap-up of what is currently happening in UNCITRAL and what you can expect to be happening from UNCITRAL, and we look forward to your continued interest in the work of UNCITRAL. Thank you for your attention, and thanks and congratulations to JPRI for a wonderful organization of this conference. Thank you very much.
Thank you, Mr. Lee. You are incredible. You are just on time. So it means now we are on the track. So I think I'm not a good moderator as the previous moderator, Dr. Komindra. So now the three panelists have enough time to speak, so please take your time. I give my mic to Athida Komindra. You sure to know her because she is the moderator of the previous session. Please.
Thank you very much. Hello again. So together we have enjoyed 2 days of in-depth discussions of important instruments that harmonize international commercial law, as that is precisely UNCITRAL's mandate, and judges are gatekeepers who interpret UNCITRAL legislative instruments. The UNCITRAL Secretariat is very pleased and honored Jae Sung Lee and I have been keeping our director, Anna Jubenbrey, posted in Vienna, and she extends again her appreciation for this meaningful opportunity to engage with all of you. My colleagues and I are especially grateful that we were able to join you all physically. We hope that you share our enthusiasm. The Republic of Korea is an active leader in many areas of UNCITRAL, particularly in the Asia-Pacific region, and we hope that these presentations inspire virtual participants from all corners to learn from South Korea's expertise and experiences. As I am the last speaker from UNCITRAL at this conference, I wanted to take the opportunity to wrap up the UNCITRAL-related discussions we've had over the past 2 days and provide a regional perspective going forward. So the key takeaway from UNCITRAL is, of course, harmonization. The legal certainty afforded by harmonization decreases the level of risk and transactional costs associated with doing business, thus promoting international trade. In addition to harmonizing trade, UNCITRAL instruments are useful as they cover the lifespan of a transaction, starting with deal-making via the CISG, which we explored during the first session. So this year is the 40th anniversary of the CISG, which has been adopted by 94 states from all regions, economic and legal systems. We are keeping our fingers crossed that there will be more positive developments in Asia-Pacific in the coming months, as the Philippines and Thailand are both seriously considering adoption. Following the CISG discussion was a session on UNCITRAL's instruments facilitating access to credit and insolvency, the model laws on secure transactions, cross-border insolvency, and recognition and enforcement of insolvency-related judgments. On the model law on cross-border insolvency, there was a recent interesting case in India where certain judges appeared to read the MLCBI into the domestic insolvency code framework, which may in turn bolster legislative efforts in India to adopt the model law. Today, we moved on from UNCITRAL deal-making and financing instruments to dispute resolution. With near universal participation by 166 states, the New York Convention provides common legislative standards for the recognition of arbitration agreements and court recognition and enforcement of foreign and non-domestic arbitral awards, subject to only specific limited exceptions, and thus facilitates the resolution of disputes in all corners. Recent years have seen more activity in the South Pacific jurisdictions, for which UNCITRAL RCAP's partnership with the Asian Development Bank has led to accession in 2019 and 2020 by Palau, Papua New Guinea, and Tonga, and we hope to see that trend continue. Like the New York Convention, the Singapore Convention on Mediation strengthens respect for binding commitments, inspires confidence in the rule of law, and ensures fair treatment in the resolution of disputes arising over contractual rights and obligations. As shown by the growing number of signatories, the convention itself is acceptable to states with diverse legal, social, and economic systems. Approximately half of the signatories are in the Asia-Pacific, including 3 of the 4 largest economies in the region, namely China, India, and South Korea. Half of the ASEAN member states have also signed: Brunei, Laos, Malaysia, the Philippines, and Singapore. In addition, 4 of the 6 states that have ratified the convention are in the Asia-Pacific: Singapore, Fiji, Qatar, Saudi Arabia, and several other states in East and Southeast Asia are considering the same. Like the New York Convention, benefits of the Singapore Convention will only be amplified as the number of state parties increases. In addition to furthering adoption of UNCITRAL texts in the region, UNCITRAL RCAP also aims to promote uniform interpretation of such texts by regional end users. This includes both raising awareness of court decisions and arbitral awards relating to UNCITRAL instruments in the CLOUT database, or case law on UNCITRAL texts, and also soliciting active contributions from experts in the Asia-Pacific, much like South Korea's invaluable contributions. In this regard, UNCITRAL and RCAP are deeply grateful to Korea's CLOUT national correspondents, 2 of whom are presenting in this conference, Judge Hyman Lee yesterday and Judge Sun-Hwa Kim, who's on the stage with me today. For regional experts watching this live stream, voluntary contributions of case abstracts from your jurisdiction would be most welcome. The Asia-Pacific database is relatively sparse still, especially from Central, South, and Southeast Asia, so we look forward to your contributions. Further details about UNCITRAL and UNCITRAL RCAP events, most of which are now virtual and publicly accessible, may be found on the dedicated webpage shown here for your reference. Because I have some time left, although this is a little bit odd because we are approaching the end of our discussion, I couldn't leave without providing a snapshot of my office, the UNCITRAL Regional Center for Asia and the Pacific. So RCAP is UNCITRAL's only regional center. We're located in Incheon, in G Tower in Songdo, which you can see there. We opened our doors in 2012 with the support of the South Korean government to carry out UNCITRAL's mandate of promoting the progressive harmonization and modernization of international trade and commercial law to approximately 60 jurisdictions in the Asia-Pacific region, working with government officials, the judiciary, legal and business experts, and academia. Examples of RCAP's flagship events are shown here. And RCAP looks forward to further collaborating with our partners, including international organizations like the Hague Conference and UNIDROIT, represented here today, the judiciary and judicial bodies like JPRI across the Pacific region to further promote the progressive harmonization of international trade and commercial law. So with that, I end my closing remarks. Thank you for your attention, and a final thanks to our co-organizers, JPRI, the Hague Conference, and UNIDROIT, and our sponsors, the Korean Bar Association, Korea International Trade Association, Korea Private International Law Association, and Association of Judges for International Commercial Law Studies. Please feel free to email RCAP at that address there with any questions, potential clout abstracts, or collaboration proposals. Once things have returned to normal, please also consider visiting RCAP in person in Songdo. We look forward to seeing you in person, and I thank you very much.
Thank you very much. Yes, I personally had the chance to serve as a rapporteur of the working group of the UNCITRAL maybe 20 years ago. So it is quite impressive to, now we have Asian Pacific Center in Korea itself. So I hope many lawyers and the participants of this conference will have a chance to visit the Incheon office and meet our Ms. Kaminder. And now I'll give it to the floor to the Judge Yoon Jung-choi, who is the judge of the Seoul Central District Court. Also, she has been on secondment at the HCCH until this year. You just, oh, this August, yes. Judge Choi, floor is yours.
Thank you, Chairman. Good afternoon. Now I think good evening, everyone. My name is Yoon Jung-choi. I'm a judge working at Seoul Central District Court. First of all, I would like to thank all the distinguished speakers and panelists for wonderful presentations and discussions throughout the conference, despite the physical distance and difficult situation. I would like to add some thoughts regarding international commercial litigation and e-service. International commercial courts across the world are mostly using e-litigation system that can help the whole procedure to be more efficient and economical. In this regard, I would like to present briefly on the current state of e-litigation and e-service in South Korea, to consider how we can make the service procedure swift and efficient in international commercial litigation. In South Korea, e-service is conducted through an e-filing system. The parties of the case are always able to view all the documents and evidence, general information of the case, service of the process, the trial date, etc., with an electronic record viewer on the e-filing homepage. If a plaintiff submits an electronic complaint through the e-filing homepage, against the defendant will be served a printout of the e-complaint with instructions on how to use the e-litigation system. This is not yet e-service. If the defendant also registers as a user on the website and consents to the progress of e-litigation, from that point on, e-service will be made. E-service in South Korea consists of 2 steps. A court clerk posts the e-document on the e-litigation system and electronically notifies the person to be served such fact by email and text message so that they can check the document themselves. Both steps are conducted at the same time through an e-case management program that court clerks use. When a court clerk selects an e-document in the e-cabinet and clicks a service button, then the e-document is automatically posted and the notification is immediately sent to the person to be served. It is different from e-service conducted in other jurisdictions where an e-document itself is served by electronic methods such as email. According to the Article 11.4 of the E-Litigation Act in South Korea, e-service is deemed made when the person to be served actually checks the posted e-document on the filing homepage. However, there might be cases where the person to be served does not check it on purpose for a long time. In order to prevent this situation from arising, the same provision also stipulates that the e-service is also deemed made when 1 week has passed since the day of notification. Therefore, the person to be served has 1 week to check the e-document posted, and afterwards, the e-document is regarded to have been served, even though he or she might not have actually checked it. If system failure occurs and makes it impossible for the parties to check the e-document, the period during which the document cannot be checked because of the system failure is not counted in this 1 week term. In most cases of international commercial litigation, the defendant lives abroad. According to the e-service system in South Korea, a printout complaint should first be served to the defendant with information concerning the e-litigation system. At the moment, this e-filing homepage is only available in Korean language and requires an authentication certificate for verification of identity. These matters are challenging for foreigners to use the system on their own. However, I think it would not be very difficult technically that we create separate platform for international commercial litigation, which will be available in English language and require different type of verification process with using the current technology. As e-service is firmly based on the parties' consent, the first document, which mostly would be the statement of claim, should be served in hard copy. Maybe sometimes it would be under HCCH Service Convention, which means it still takes a long time to serve a hard copy document to the defendant abroad. In international commercial cases, the parties usually include a jurisdiction clause in their contract. Likewise, if the parties already agree that the statement of claim can be served to the counterparty by email with a particular email address designated in their contract, and if the forum law allows this kind of service under some requirements maybe, the statement of claim could be served by email. However, I think it is still unclear how we can deal with the situation that the defendant argues he or she have not received the email, and there is always risk of system error. To sum up, I would like to emphasize that when we pursue the development of international commercial litigation and consider establishing an international commercial court, we need to think about how we can make service system efficient and swift, taking into account the feature of international commercial litigation. Thank you very much for your listening.
Thank you, Judge Chair, for your wonderful contribution to this conference. Yes, we heard about the Korean situation of e-litigation and e-service. Actually, the Korean e-litigation system was has launched in maybe 10 years ago. At the time, I was working at the National Court Administration of the Supreme Court of Korea. And when the Supreme Court decided to launch this system, at the time, many judges and lawyers do not like the idea of e-litigation and e-service. But within 10 years, actually all things changed. Nowadays, I think almost over 90% of cases on civil procedure are dealt with in e-litigation. So it is very convenient, very secure. So if we can connect with the other members of the UNIDROIT or UNCITRAL, like the Singapore, Hong Kong, or Japan, then it is not impossible. It will be possible to make e-litigation and e-service between member states. I hope we will see that happen in the near future. So I'd like to give this floor to our last panelist. I'll introduce Judge Sunhwa Kim, the judge of the Suwon District Court. She is now serving as a national correspondent in Cloud to UNCITRAL since 2017. Yes. Judge Kim, floor is yours.
Thank you, Chair. Ladies and gentlemen, honorable judges, good evening. I am Judge Kim Sunhwa. It is my honor, especially to be the last speaker of this conference. I want to start with introducing my experience of national correspondent for UNCITRAL. For uniform interpretation and application of the international trade law, UNCITRAL uses cloud system. The system provides summaries of court decisions relating to each provision of trade law convention. Judge Lee Hae-min was first appointed as national correspondent for Korea in 2009, and I was additionally appointed since 2017. As national correspondents, we first choose several lower court or Supreme Court decisions which seem to have important implication for resolution of trade disputes. Then we summarize the decisions to make abstracts, translate them into English, and submit them to UNCITRAL. Submitting Korean decisions to cloud system seems to be one of the efforts of Korean courts to ensure efficient resolution of international trade disputes. So far, we submitted abstracts regarding CISG and the New York Convention, and I want to share two implications from overview of Korean court decisions. The first one is about the public policy exception to recognition and enforcement of foreign judgments. For the foreign judgments or arbitral awards to be recognized and enforced in Korea, such recognition and enforcement should not be contrary to the public policy of Korea. Also, New York Convention, Judgments Convention from Hague, and Singapore Convention set forth defenses to refuse recognition and enforcement, which are against public policy. However, in practice, I found this public policy exception is somewhat countervailing to the principle of prohibition of revision of fond, which means the court is not entitled to review the merits of the case. Many decisions from Korean courts show the tendency to interpret the concept of the public policy strictly. The term public policy used in conventions is understood as international public policy rather than the domestic or internal public policy. In this regard, many decisions announced that if the foreign arbitral awards are against Korean mandatory law, that alone would not justify the public policy exception. And as there already are provisions dealing with important procedural flaws, the public policy concept plays even more supplementary role in procedural aspects. So far, the Korean precedents seem to have accomplished adequate balance between the prohibition of revision of fond and the public policy exception. And the second issue is about the application of CISG. In many cases regarding international contracts for sale of goods, the first and foremost issue was whether CISG can be the governing law to the legal relationship surrounding the transaction. as Article 6 of the CISG explicitly endorses the freedom of contract. Sellers and buyers are not bound to accept the default settings found in the convention. However, in many contracts, parties even don't clarify which law should be the governing law in case of dispute. And for this reason, Seoul High Court stated that such an agreement of exclusion needs not to be explicit. But if such implicit exclusion is approved, it can create a lot of problems in conflict situations, as it will be hard to compromise different intentions of both parties. Thus, I think the exclusion should be explicit. That is, the contract term should exclude application of the convention and also state what law is to govern. The predictability and stability of transaction practice can be strengthened only with such obvious and concrete exclusion of application of the convention. While working as national correspondents, we could review the trends of Korean decisions and could check whether our trial practice lives up to the purpose of the convention. And finally, I want to wrap up with a little suggestion. I think it will be a good idea to publish a guidebook for Korean judges, which explains the main contents of major decisions submitted to cloud system. It will be a good reference for international transaction cases and also help courts to properly interpret and apply the provisions of trade law convention. Thank you very much. Thank you for listening.
Thank you, Judge Kim. I regret my role as not as a moderator, but as a facilitator. So we start behind the schedule, but now we are very fast on schedule. So we have more than about 10 minutes. So, but I cannot find any question from the floor. So if you have any question or comments, you have time to make any comments or questions. I cannot see anyone. If you have any more comments or question each other, the panelists, do you have any more additional comments or questions? No. In that case, I'd like to invite the members of the JPRI to make a kind of final announcement of this conference. Maybe the president or the chief of the administration. Yes, please. I can give floor to. Thank you. Please give a big applaud to the president of the JPRI.
네, 감사합니다. 저는 뭐 영어가 안 되니까.
Thank you very much. I'm going to speak in Korean. So for the past 2 days, thank you very much for being with us, a lot of experts and also the justices and the foreign participants. Thank you all for gracing us. And I believe that the conference has been very successful, in fact, more than what we initially expected. And through this international conference, for the international commercial law, and also the litigation sectors, we can actually see that how rapid changes are taking place. And the JPRI will continue to step up our efforts in order to have researches on this matter. And also I myself thought that we should work harder to promote international exchanges and cooperation. And in fact, for this year's conference, we actually planned for the offline conference. So we wanted to invite everyone from overseas to Korea, but due to the COVID-19, we actually made this new attempt of conducting a very hybrid conference. And the staffs and the researchers of the JPRI made tremendous efforts. And as a result, we were able to have a very successful conference. I would like to thank them for their great efforts to put together this conference. And also the many panelists and also the speakers and the discussants. Thank you very much for your contribution.
Thank you very much, Mr. President, for your kind words. And now we can wrap up this conference a little bit earlier. As a final statement, I want to say this one. Because of COVID-19 pandemic, we cannot meet each other in this beautiful venue. But thanks to the digital revolution, we can meet with the screen, and we can talk with each other. We can share our information and the ideas. And we found that the idea of the common justice in the field of international commercial litigation, it is very common among not with the geographical or linguistic or any race. We share the same idea and same techniques and same kinds of concept of procedural right. In this sense, we can make kinds of global cooperation in this field with the help of our sponsors, UNCITRAL, UNIDROIT, and all other organizers and sponsors. And in this sense, I would like to express my sincere gratitude to all the members of the host organizations and sponsors. Thank you very much, and good night, and good morning, and good afternoon. Thank you.
Thank you very much. I appreciate all participants of the final plenary session for actively participating in the discussion. And I also appreciate Chair Kang and President Hong for their wonderful closing speech. Now we have reached the end of the two-day conference. As the president of JPRI said yesterday, I believe that this conference will serve as a stepping stone to look at the past and present of the international commercial litigation and to design its path forward. It was my great honor and privilege to be a master of the conference. On behalf of the JPRI, I would like to extend my heartfelt gratitude to all participants for sharing your valuable insights and experiences. I deeply appreciate for all of your expertise that you brought to this conference. I would like to thank all of the staffs who have been working so hard to put this together, and my special thanks go to the interpreters who have been breaking down our language barriers for the entire conference. Let us give a big round of applause to all of the participants. Now, this concludes 2020 JPRI International Conference. Thank you.